What officer? What officer? What officer? What officer?
ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು. ಯಾಕೆ ನಮಸ್ಕಾರ ಆಗ್ತಾ ಇದೆಯಾ ಜಡ್ಜಿಗೆ ಜಡ್ಜಿಗ ಬಂದ್ರ ಬಂದ್ರು.
You've
Yes,
received.
now I am received, madam.
It is submitted that no notice had been issued by the tribunal to the other private respondents in the matter. It is further submitted that the copy of the writ petition has been served on the caveat. The office, the office objections are therefore overruled. List for admission. Wednesday.
Number 2, Satish K.
Suspension. But I will.
Whatever is required, you will give us copies, translations.
Short pointing, but I was pointed in the in an assistant teacher. But in respect of my selection, after about 9 years, nobody gives a complaint. But based on that allegation, on 6/2/2023, but I was placed under suspension. But pending inquiry, 6/2/2023. But I challenge the order of suspension on the ground that 6 months is already expired. I have made a representation.
No charges.
Charge memo is issued on 15/3/2024. And Lord, in the criminal case is also listed, Lord, charge sheet is filed on 24/11/2023.
Yes, trial is going on.
Yes, but I challenge the order of suspension. Tribunal allows my application, quashes the order of suspension, denies any mistake. May I request the Lord kindly take Lord page 46 of the tribunal order.
That is an office objection. Yes,
Para 8. After perusal of the materials, the short point involved in this application is whether the suspension order under challenge 6/2023, which has come into effect from 19/10/2022, as mentioned in the suspension order, is sustainable or not. As on this day, the life of suspension order is 6 months, as per Rule 10(5)B of DCCCA. Therefore, within the period of expiry of 6 months from the date of suspension order, articles of charge to be issued. It will be not issued in the said period of 6 months, or if the executive authority has not taken decision to extend the period of suspension within the period of 6 months, then after the period of expiry of the suspension order from the date of suspension, it is deemed to go. In this case, while arguing the case, the counsel for the applicant made a description that the memo is issued against the applicant on 5/6/2023 and charge sheet was submitted on 24/11/2023. The counsel has not disputed the dates as submitted by the counsel for the applicant. Looking into the
just a moment, Council 5623.
not wrongly mentioned, not 5/6. Please note the 15/3/2024.
That is the date you gave us. If that is so, you're right. But if it is 5/6/23, then it is within the 6 months.
Yes. If anything that could not expire,
In this case, while arguing the case, learned counsel for the applicant made the submission that charge memo issued against the applicant is dated 5/6/23.
and
Charge sheet submitted on 24/11.
yes, the relevant additional government document is not excluded in said date as submitted by the looking to the suspension order, though it is dated known to.
Okay.
In fact, it is given to the suspension order dated 19/10/2022. So 6 months has to be calculated from 19/10/2022. It will be expiring on 19/4/2023. Therefore, looking to the date of issuing the charge memo in the department on 5/6/2023, it is more than 6 months expired. After expiry of 6 months, as per the statute, it is presumed that during the revocation of the suspension order, as to now, the suspension order is not at all in existence. It is already revoked as per the statute. Therefore, according to the statute, the law, including order. But looking into the nature of the document, he has created fraud and misrepresentation for the respondent authority. Obtained the employment as a lead, and in the criminal case, the charge sheet is already filed. Wherein this applicant is read as key number 10. When such serious allegations are there against the applicant, even according to the charge sheet filed in the criminal case, it is not proper and advisable for the ordinary means, only to that extent that I am for the law. But
Is the order days has to be reinstated? Not only that, Masilamani is after the conviction. Masilamani applies after the conviction.
after the. But the tribunal.
I'll get instruction. It appears,
Please get
May-
instructions on this point.
appears to be,
If, as a matter of fact, the charge sheet is only on 15/3/24, there is no issue at all.
once the
Here-
suspension
here
becomes
also-
automatically
Correct.
revoked.
Here also, the tribunal says it has to be taken note of from the date of effect of the order of suspension. If that is so, even 5/6/23 is beyond.
Yes.
But on fact, 5/6/2023, but charge memo was issued by an incompetent authority, therefore it was withdrawn, and fresh charge memo is issued on 15th. I am working in Lord Bangalore urban district. Competent DGPI is the Bangalore urban. So Chikballapur DGPI had issued, therefore that charge memo was withdrawn, and fresh charge memo was issued on 15th.
The office objection is dispensed with for the time being. If there is anything required, please make it available. So now translation is not an issue at all. You can get it done by AI in no time.
The only short point, I am not back on either.
For instructions, the learned government
That's
advocate.
it. Next.
Yes. Takes notice on behalf of the respondents and seeks time to get instructions. List after 2
That's-
weeks.
2 weeks.
Third matter, yesterday's matter, instead of 20%. Similar matter.
List on 21st. We list it on 21st.
Easy.
That time, seal number 3, Abhishek Chandragowda.
Yes. The learned counsel for the petitioner seeks a week's time to comply with the office objections. The week's time is granted. Issue notice to the respondent. List after service is complete.
Orders, seal number 4, Janardhanji.
Most of my Lord application is filed for the copy. Again, I finally.
Respondent, my lord, was not heard because, my lord, the council was representing the respondent earlier. My lord was very ill. She was hospitalized. And therefore, my lord, order is passed, my lord, without hearing the respondent. Therefore, my lord, order 41, rule 21 of the CPC, my lord, enables
I find the counter not yet delayed, not finally.
rehearing.
Name has to be shown. Wakalat is filed on.
Divorce granted.
Sorry, my lord.
Divorce granted.
Yes, my lord, granted.
Not delayed filing the application, but the calling even for sufficient option.
Yes, my lord.
Order sheet is very clear.
Lord, the advocate on record for the respondent, my lord, was hospitalized. It is for this reason that, my lord, there could not be adequate representation. We are not finding fault with the court, my lord, but this is a difficulty, my lord, that was faced by the respondent wife.
Yes, show the name of the.
Office
learned
objection
counsel.
says, my lord, that application is not maintainable. That may be overruled, my lord. Order 41, rule 21 is very clear that it is only an application that is maintainable.
Is overall for the time being. Show the name of the, record the wakalat and show the name of the learned counsel for the respondent. For objections, list after 2 weeks.
Very well. Some date, my lord. Grateful.
We'll give it.
2 weeks. Great note, 2 weeks.
3rd July.
Good. I request for 4th, my lord. 4th. Great.
Five, Prashant.
That PDA and making take from Hyderabad. I am not contesting that position. I will file as though the appeal subject matter is the appeal in the trial court and pay accordingly. That DD I am getting just today. Kindly posted on Wednesday and go into the matter.
Wednesday.
There is one more office objection which has come up curiously for the first time today, saying that I have not complied with the order to deposit 25 lakh. But that I have already clarified, I am not pressing the IA. So that may be.
That is not noted. So if he is not pressing the IA, I may permitted to go ahead with the execution.
Okay. And those IAs I am not pressing.
Application for stay.
Application for stay I am not, because there is no money. I have already submitted that this company is under securitization. All the assets are already taken.
Not, this is the purpose,
Right.
repeating the entire thing.
Learned counsel for the appellant submits that the appellant is not pressing application seeking stay of the judgment and decree. Full stop. Submission is placed on record. Application is dismissed as not pressed.
Then there is a deposit of 20 lakhs, my lord. I may be permitted to withdraw. No, he cannot object, my lord. He does not press for stay. He has been deposited pursuant to a conditional order, but he cannot press for that, my lord. The 20 lakhs, my lord, for 13 years, I do not
Just a
have.
second, just a second.
The decree is for an uncertain amount. The prayer was for 7 lakhs. I have already gone out of pocket by 25 lakh, out of which 5 lakh has been given to him. Remaining 20 is deposited with this court. I am only asking for hearing on Wednesday. Till then, let him not withdraw.
Wednesday,
Wednesday.
we'll hear.
Not I have.
Six, Sridhar, Prabhu.
For the appellant in this matter, my lord. Please, my lord. The office note says, my lord, that appendix 1 at page 18 that I have produced has to be verified with the trial court records. My submission is, my lord, in trial court, I had not submitted this schedule. In fact, my lord, that is one of the grounds why, my lord, the honorable trial court said that amount is undisputed, but how it was paid and what is the mode of payment is not, my lord, disclosed. In page 35, my lord, I have stated that how that amount also has been paid.
What is appendix 1?
Appendix 1, my lord, is the detail of the payments made. In fact, my lord, I am unsuited before the trial court on the ground that amounts are received, no doubt. It's a specific performance suit, my lord. Amounts are received, no doubt, but how that amount was made and what is the mode of payment was not disclosed. So I have tabulated that, my lord, in appendix 1. So that was not part of the trial court record, my lord. In fact, the amount paid, lordships may see in page 34 onwards, my lord. The next
Objection.
objection is, my lord, that they need to verify this appendix 1 with the trial court. I have not produced that trial court record, my lord. These amounts are now, I have just made a table and put it, my lord. That how I have paid this and what check number when it was paid.
Office objection relating to non-production of appendix 1 said to have been placed before the trial court is overruled.
Lord, I'm praying for an interim direction, Lord. Specific performance should not to alienate. That's all, Lord, I'm saying. Otherwise, it will become infructuous. Payment is made. It is acknowledged.
Application is not listed.
It is, sorry, Lord, it is part of the, I'm so sorry, Lord. Because it was an office objection, Lord, it could not be. May I persuade your Lordship to see the main petition
You
itself?
had the benefit of, no, you had the benefit of interim order.
Yes, Lord, in the trial court. But later, my Lord, I am unsuited. That's the difficulty. Payment was, that's why, my Lord, the property is not alienated yet.
The plaintiff is in appeal, challenging the decree for decree of dismissal of suit for specific performance. Full stop. An application is filed seeking temporary injunction to restrain the respondent from alienating the suit schedule property. Learned counsel for the appellant further submits that the appellant had the benefit of interim order during the pendency of this suit. Considering the nature of this suit and also considering the fact that the appellant had the benefit of interim order till the disposal of the suit, the respondent is restrained from alienating the suit schedule property till next date. Issue emergent notice. Call for records.
Obliged, grateful.
Seven, BB Vidyulata.
Served it on upon Venkatesh Arpati, respondent number 2. I also filed a memo to this regard. Last occasion when I need submission to your lordship, so I served on the standing council. I have served Venkatesh Arpati. His name is shown.
Name is not shown.
Not shown. Show the name of the standing council for our. This is a matter of compulsory retirement. Any time next week, some date, and so that. In 2020, it is being. 24th. Obliged.
Venkatesha.
Name may be shown.
Venkatesha.
Obliged.
Eight, Mahesh.
On it, my lord. On the same time, kindly say, my lord. Other side, my lord, more than 3 or 4 times, they have taken time for filing the translation copy. Now, I have produced the day, 2 hearing date before, my lord. I produced the rules, C&R rules. I have filed the vacating of the interim order, my lord. Let the interim order vacate, my lord. Let them take a time, my lord. Yeah. Yeah,
It's over.
yes.
Pass over today. Pass over.
Okay.
Nine,
But meanwhile, court officer may be directed to secure the translation copy from.
Yes.
nine,
Yes. Then council seeks time to produce the translated copies of the lectures list after a week. Please give a date.
24. 10, Ajit PB,
Present respond number. Permitted to file wakalat for respondents 1 to 15.
1 to
15.
15.
1 to
15.
What about 16 and 18?
16 and 18 unserved.
I'll file wakalat
Tell me the
for
list.
16 and 18 also.
Also.
16 and 18 also you get.
I'll secure the wakalat and I'll file it.
Yes.
The date may be fixed on 26th or 27th.
Learned Council
Have obtained interim order.
submits that wakalat is being filed for respondents 1 to 15 as well as for respondents 16 and 18.
Please.
The wakalat to be filed. List after a week.
Your Lordship kindly fix a date.
Yes,
There is an interim order operating against us.
extended till then.
27,
Highly.
11, Chandan Gowda 40,
Notice is served.
He appeared before the trial court
No, madam, no one appeared, madam. No notice was ordered before the trial court
against R2.
regarding maintainability. The court,
Who's R2?
without issuing notice, order has been.
So there is no prayer before the trial court against defendant number 2? No prayer before the trial court?
No.
Then why is made a part?
Ejectment of defendants, both the defendants.
Sought
it is
relief
sought,
against
madam.
both.
It's for both the defendants.
Defendants. Not the plaintiff is exempt. An order is in favor of defendant number 2 also.
Yes,
You can't dispense with the notice.
Yes, please comply. Yes, the office object. Weeks time granted for complying with the office objections. You'll have to take out notice. Notice will have to come back. This immediately after service is complete.
12,
Yes.
13, Prithvish,
Lord, only one submission. Lord, this writ petition has a checkered history, my Lord, with regard to transfer of, my Lord, sub-registrar with, my Lord, shifting of the post. But those orders are not produced. May I request, my Lord, those orders are, my Lord, I have to get it, my Lord, on short accommodation, my Lord, maybe on 26th.
Current.
But it is not a, my Lord, plain transfer. It is shifting of post. My Lord, this honorable court has taken note of the fact that, my Lord, there cannot be a shifting of post. My Lord, summoned the principal secretary and an affidavit was filed. Those orders are, my Lord, required to be produced.
Only for translation and still only 2 days time. It's almost ready. So when
They are producing all those records.
it's all produced before the government tribunal, even for the applicant before the, I mean, respondent before the tribunal.
We list on a date.
Yes.
On that date, if you find that the orders are not there, then we can list it on another day for
Yes.
production of the necessary.
26th.
26.
This is mostly 19th or 20th. Will I take a
But
chance?
but there are many I have also given for translation, not the, it is not,
25th.
Government advocate.
But the service has to be completed on the respondents, my lord. We'll take steps immediately. It may be taken up in the last week of.
Okay, for the response.
Which respondents are you
1
appearing?
and 2 minutes.
Sorry,
1 and 2 minutes.
1 and 2 you appear.
Yes, minutes.
Now 3,
We have to serve.
3 and 4.
I have filed the wakalat also.
4 I appear.
So 3 has to be served.
3 and 4. 4 I will serve on the council for the
The
local.
server
I will.
copy. Yes, for completion of
May I
service.
accommodate a
on
short
3.
accommodation, minutes.
Manjunath
Yes.
My lords, it's a, if I can say, my lords, a civil dispute between two, which goes till RSA. And one person seeks a cart road which is given to his land. He says that way is blocked by the other. And he approaches Tahsildar Sagar. And meanwhile, my lords, he files a complaint before the Lokayukta saying that there is inaction. My lords, clearly hit by section 8 and also schedule of the Karnataka Lokayukta Act. And on that, my lords, inquiry is held by Lokayukta and increments are withheld, also pensions are
Disciplinary
withheld, which
proceedings
is
are,
being
disciplinary proceedings are initiated.
on the maintainer plea itself, my lords, it has been quashed. That's why. Interim order is in their favor, my lords. I'll move the modification, vacating, my lords. My lords may grant me some time, but not more than a week, my lords. It's my humble request. It's my humble request.
List for completion of service on R3 and for primary hearing. R3.
Manjunath.
R3.
R3 is filed.
Manjunath. Yes.
1 and 2 nano.
R4.
R4 is ready.
R4 is there.
I'll complete on R4.
Service is complete.
Served it, so service complete. When shall we have this?
My lord, anytime last week of this month, man.
27th of June.
20.
Much obliged.
15, Satish K.
Regularization. There were 13 geologists who were appointed during the year 1985-86.
Yes.
And,
How were they appointed? After due selection process?
But they,
Not against sanction post though.
they were these against sanction.
Hmm.
But our services are regularized.
Hmm.
There is no dispute with
Hmm.
regard to those.
It is the earlier date of regularization.
Yes. But persons, not totally, there were 30 geologists. Out of 30 geologists, 8 were regularized from the date they have completed 10 years of service. But those 8 were given all the benefits. Thereafter, my lord, after 2 years, but the retrospective regularization was withdrawn against 8. At that time, my lord, we were not regularized. But the withdrawal of retrospective regularization was challenged with the tribunal. The tribunal allowed the application and quashed and given a finding that they are entitled for retrospective regularization. State being.
Because it had been granted and withdrawn.
Yes.
Hmm.
Yes. It was granted and withdrawn. Yes. But against that, my lord, the state preferred a petition. But by order dated 8/2/2016, the state's writ petition was dismissed,
Yes.
affirming the order of the tribunal.
Hmm.
Thereafter, my lord, we have been regularized. We were appointed along with those 30. Undisputed fact is, my lord, we have been appointed along with 30. But we were not regularized prospectively from the date, not the order is issued. But we approached the honorable tribunal, contending that similarly situated persons have been regularized on completion of 10 years. We are entitled for regularization on completion of 10 years. The tribunal has dismissed my application because on the ground that you have accepted that order, therefore you cannot challenge.
Did you challenge it immediately after your,
Yes.
the regular, you did?
But I, earlier, my lord, I had challenged before the tribunal. Tribunal directed us to give a representation. But the application was disposed of. with a direct-
Representation was dismissed.
No,
Which
rejected.
is,
Is that page 210 is the order passed in the earlier round of.
what is the office objection here?
Lord, I'll get instructions.
Yes, this is the first time.
It's listed for the first time.
Yes, learned, government advocate accepts notice for the, or is there anybody else? Other parties are there. Should not government advocate accept notice for respondents?
Are 1 to 4 months.
Or 1 to 4.
As far as concerned, is the co-applicant along with us had approached.
He did not
He's-
file.
He was the co-applicant. He did not challenge, he has accepted the order.
Notice to R5 is dispensed with in view of the submission that he was a co-applicant along with the petitioners before the tribunal and has chosen not to challenge the order of the tribunal. Yes, list,
Last week of this.
yes. 28th.
Hearing on IA, number 16.
I have no objection for taking up this matter for final hearing, subject to only one request to this honorable court. Kindly see the order dated 12/12/2023. I have filed an application for setting aside the ex parte order of injunction granted against me in a suit for partition. The appellant is the purchaser of undivided share in joint family properties. How is he entitled to seek injunction against me as a true owner of the property? It is a settled legal principle, your lordship, that purchaser of an undivided share in joint family
Suit
property.
is decreed or what?
Suit is decreed, it is in my favor.
You are the plaintiff.
And, but we are the plaintiffs. And the appellants, my lord, being the purchasers of undivided share in joint family property, they did not have any advantage of any interim order.
You are not a party to the sale deed.
I am not a party to the sale.
What is the property?
In fact, on 12/12/2023, an order is passed. Kindly look at the order on 12/12/2023, my lord. Heard Sri H.N. Manjunath Prasad, learned advocate for aviator respondent number 15 and Sri Prabhuling Tambigi, learned advocate for appellants. Sri Manjunath Prasad filed synopsis today. The same be kept on record. The synopsis contains genealogy of tree. Adverting to the same, he submits that the appellants have purchased the land measuring 5 acres 77 cents in survey number 95/2, 1 acre out of 8.42 acres in survey number 95/4 and 0.43 cents out of 5.77 acres in survey number 95/7 from legal heirs of late B.B. Ramchandra. The daughters of late Ramchandra have filed OS number so and so, seeking partition and separate possession. The suit was decreed appellants were parties in the FTP number so and so. Appellants have not been allotted any piece of land in the aforesaid lands. The appellants who are not in possession of any piece of land are now trying to interfere with the possession of the respondents. To a pointed question as to whether the appellants were allotted any land in FDP number so and so, page number 48 of the synopsis, the Prabhuling Tambagi seeks time to complete instructions.
So is he a party to the suit?
Yes, he is a party.
Party to the suit?
That suit
Original.
filed by his vendors.
FDP is complete or what?
FDP now have challenged before the district court, it is stayed. He has not been allotted anything. FDP proceedings, though he is a party, nothing has been allotted to him. So your lordship may kindly say.
You are challenging the preliminary decree. You are challenging the preliminary decree. On what ground?
The entire record clearly shows that all 1 class of 19 should be shown. Not the partition took place in between not the children of one of the women. Not the and not the record. Also not the clearly shows that not the artist. Some of the articles were not the standing in one of the different branches. Apart from that, not the bifurcation of the property. That clearly shows that not the partition. Not considering that fact, he has approached. Even not standing in prayer of not the partition should. They have not made me as a party not initiated on the partition. And subsequently my property and was included and not the after not the coming on because by the different numbers not included and not the one not I have purchased this property not in the year 1993. And not the
93. Suit is filed in which year?
Agreement sale was 1993, not the.
All right, 2013.
Registered on not.
When your names were entered in the property record?
After lapse of 18 years.
When your names were entered?
Entered in not 2004 not.
2004. So when the suit was filed, the name was there in the property records.
No. 18 years or now only after filing of the
Just a second. He says it was entered in 2004.
2004 agreement of sale was there. Possession was not handed over.
Answer a specific question. When your name was entered in the property records? Give me the year. He says 2019.
I have produced the records of rights along with IA number 3. I have produced IA number 3. Objections I have produced. Your Lordship may kindly see after lapse of more than 14 years from the date of purchase.
Records are received. Records are received.
Records there.
We'll take up for final disposal.
I have no objection. Only thing is now taking advantage of this order. He has filed a suit against me stating that I have trespassed into my own property and filed a suit for recovery of 5 lakh rupees. Whether it can be countenanced on the basis of an order passed by this court. That to an export order.
What is the order granted by this court?
Pardon me?
What is the order granted by this court?
The order dated 545. The order dated 5/10/2023.
What does it say?
Application is filed by the appellant number 1 seeking temporary injunction. Peruse the application along with documents attached thereto. The summary advocate for appellant submits the respondent or interfering with the first appellant possession in respect of schedule item number 25 mentioned in the application. The learned advocate submits the respondent number 5 is not interfering with the possession.
It's agricultural land.
Agricultural land. We are in possession of the property. And there shall be an ad interim order of.
You are the daughter.
Pardon, no, we are on the other branches, my lord. I have produced the synopsis. We are all the brothers of this one. Brothers. Only one brother has sold the property.
We'll fix a date for final disposal. Short date.
Till such time the order may kindly be kept in abeyance because I approached the police also.
No, it's like this. If you have to pass an order on this application, you have to hear this. If you are agreeing for final disposal, we fix a short date.
Yes, sir. I leave it to your lordship.
Which date? On that date, you should not seek adjournment.
By moving the order of the members.
When do you want?
Any day, any convenient to your lordship, next week. I'm ready to go ahead with the matter.
25th, 25/6.
Much of. Please, let him not precipitate, my lord. Kindly direct him not to precipitate the matter because he is going to the police station also on the strength of this order passed by this court. We have been humiliated before the police.
Don't pursue the complaint.
My lord.
Civil dispute, don't pursue the complaint.
He as a purchaser of property from one of my brother, he is entitled for the share which he is likely to get it in FDP proceeding. Now the FDP proceeding is also stayed by the Supreme Court. Now taking advantage of this order, how he can interfere and file a case against the owners of the property, co-owners of the property.
23rd.
He did not have the benefit of any
25th.
interim order before the trial court.
25th.
Much of.
17, Gonzalez Guram.
I appear for response.
Now you are deposited.
Yes.
So application is filed to condone the delay of 35 days in depositing rupees 29 lakhs as ordered. Full stop. A learned advocate for the respondent fairly submits that he has no objection to condone the delay in depositing the amount of rupees 29 lakhs. Application is allowed, delay condoned. The amount shall be, the deposit shall be deposit is accepted, and registry shall deposit the amount in nationalized bank in interest earning deposit with mandate for auto renewal. 2 years, for a period of 2 years.
Srikanth MP.
What is the matter about?
Was challenging. As the rule was challenging.
Challenge against the rule. Is that so? Is it a challenge against the rule?
The
And what did the challenge was repelled?
Weightage was challenged, it was rejected by the tribunal. That's all.
It's next week.
Amendment 1.
Paid. Submitted that the court fee has been paid.
Review petition was challenged. Review petition was dismissed.
But in the writ petition number 154464 of 23 is concerned, it become infectious because he has questioned, he has approached this court on the interim order. Now the final order has also been passed. I produce a copy of that along with IA. Therefore, that can be disposed of, have become infectious. The other matters will not be here.
What do you say?
Lots of granted interim order, being the tribunal's order. In the interim order, we have been promoted to the next cadre. But if this is petition in the connected matter, it is again the final order. There is no interim order at the hands of dishonorable court. Therefore, the first petition is disposed of, so it would affect the petition. As location, the similar petition was made. Not said
All the
Yes,
petitioners
sir.
in the connected petition are not parties in the first petition. Therefore, the first petition
Yes,
has been
sir.
disposed of as having become infructuous. The other matter which has been filed by my learned friend, they can
They
argue
should-
the matter and send the
Yes.
dishonorable court for grant of interim order. They can't have the protection of the interim order in a
Granted,
petition
yeah.
which has become infructuous.
Have you not questioned the final order of the tribunal?
It has
Yes.
been
Parties, they are parties in the
connected matter.
Yes, they should have be very vigilant saying that because since it has become infectious, they should have rectified all the defects at the earliest. This is the,
The second petition is filed challenging the final order.
yes.
Then how the first petition survives?
interim order operation.
Can't see protection.
Because this is not the, this came from last several occasions. The matters came to,
By virtue of the interim order, we have been promoted.
no, according to,
Bifurcation of the department and preparation of inactives. We are not arrayed as a party before the tribunal. But the inactives pertaining to about 600 persons has been quashed by the tribunal. And without arraying us as a party. We have not been heard. We filed a review petition. In the review petition, the interim order was rejected. Against that, first petition was filed. But this one court has granted interim order saying this.
No, sir, my contention is that by virtue of the interim order granted by this, their selections itself have been quashed by the tribunal. Now, by virtue of the interim order granted by this tribunal, they are continuing in the post. They are not entitled, even the dishonorable court, also interim order has passed, they are not entitled for any promotion. Because by virtue of I filed a detailed reply in my application, in my writ petition.
We'll hear the second root petition for the interim order.
There is no interim prayer here.
They start for interim prayer, but they are not.
That we'll consider the interim prayer.
May I request, kindly take plot 16/8/2023, but this one will court, but granted an interim order of stay. But despite the interim order, when it was put to the notice of the tribunal that there is an interim order operating, and not the order dated 16/8/2023 was produced to the tribunal. But tribunal proceeds.
Was it the stay of the proceeding?
Yes.
Huh? Was it the stay of the proceeding?
What was the interim order dated 16/8?
16/8.
Review petitions were slated for hearing on 14/8. On this date, the submitted service of process has been ordered. So and so, so and so. Application filed under 23, seeking permission to file review application. Order dated came to be allowed. As regards interlocutory application filed in the review applicant. Tribunal has declined grant of relief.
What was stayed was A6,
However, this is the attention of the learned.
not the further
counsel.
proceeding.
Petitioners hearing
Yes.
were not made parties to the proceedings, keeping in view the submissions made by the learned counsel. Impugned order dated 22/5/2023, passed by the KSAT Vide A6 is hereby stayed until further orders.
Yes.
A6 is stayed.
Yes.
Hmm.
A6 is the order part in original application.
Hmm.
But A6, kindly come to your annexure A6.
Hmm.
Is at page 144.
Hmm.
When this was stayed, but can tribunal proceed in the review? Not.
The review was against this very
Yes,
order.
The review is against this order. But this one court has stayed the order part in not annexure A6. But we had filed a review, seeking review of the order at annexure A6. Tribunal, not we brought to the notice. Tribunal proceeds and passes an order which is challenged in the second.
So review was allowed. Review was,
Dismissed.
Sorry.
Review has been dismissed
Ah.
for the
so further proceeding was not stayed.
A.
Once AC review petition is dismissed, what is to be stayed?
But application, original application order was stayed.
Review petition is dismissed.
The order reviewed against. Order against the reviews.
I have not made mention, not original application, but order passed in application number 2800 of 2022. Was stayed by this honorable court. But we had preferred review, seeking review in application number 2800. But is it not the tribunal in our case should have awaited the order?
Stayed. So review could not have.
We'll have to hear it together. We'll have to hear the matters together. The second root petition, we'll issue notice. Will you accept notice of the?
Have filed wakalat for some of the respondents.
Yes. WP 24960 of 2023. It is submitted that the office objections have been complied with and the court fee paid. The IA for dispensation of production of translation copies can be allowed. is allowed. Please see that the translated copies, whatever is relevant is made available. Yes, therefore, don't allow it. It is submitted that the translated copies will be made available within a week. List. The learned government advocate accepts notice on behalf of respondents. In the second one, 24960. For the official respondents.
33.
Council, who do you do this for?
Next, I have filed on behalf of respondents, number 1, 3, 6, 8, 9, 11, 14, 23, 25, 26, 28 to 32 minutes. Rest of the respondents, Your Lordship.
33 and 34.
33 and 34 are by the government. Government advocate for official respondents, so and so for these respondents. Here, petitioner shall take notice to the unserved respondents. List. Yes. In WP 15464 of 2023. Even though it is submitted by the Learning Council appearing for the respondents that this writ petition is become infructuous in as much as the review petition itself has been dismissed. We are of the opinion that this writ petition requires to be heard along with WP 24960 of 2023, list along with the said writ petition for further arguments on week after next. The interim order granted in the earlier writ petition shall continue in force. There's nothing to be extended. Yes, so there's nothing to be extended.
Yes.
Gun pleader. He's not taken notice as yet.
No, they have not appeared, but he has to take, he has to take process, he has to pay process and notices to go. But I have no instructions to take notices on behalf of the others. Whatever, I have appeared, but they have not contacted me. Even in other case, I handed out the no objection has been given to by me.
Listed after.
He has to take notice on them.
Yes.
Twenty. 27. Tenth July.
Yes.
20.
Not appearing
Government
for the
advocate.
respond number 1 and 2, my lord.
This may be taken up sometime in the end of, AG is appearing in this matter. He has requested, he has some inconvenience today, maybe taken up
When do you want it?
anytime during the last week of this month.
28th.
Please.
Grateful.
21. A Gunashekaran.
Section 57.
You should communicate to him.
There was a,
Did you speak to him?
there was a direction to deposit the rents. This court said pay the rents. It does not even pay a rupee.
How much time you are willing to give? Just second, just second.
It's not a working industry. But the fact is this, what is let out to him is a unit with machineries, plant and machineries. He is not working in that. It's not working.
So how much time you are willing to give?
Maybe 3 months or 4 months, subject to the discretion of the court.
No, you're not doing anything there. There is no production. If it is a working unit, we can think of. It's not working. No, machineries may be working, but nobody to operate.
But missionaries are my missionaries, which I have given it to him on rent.
And then employees will be these are the machines that are installed. With all these machines, the mind.
On this point, there is adjudication. On this point, there is adjudication relating to the ownership of machineries.
The question is this.
You should know. And that is pretty.
Point is this. This was not the subject matter before the court. And throughout the trial, he did not whisper a single word that he owns some missionary.
All right, in execution proceeding, its contention is raised.
In the execution petition, for the first time, he says, when there is an order of ejectment, that his missionaries are there. If his missionaries are there, he can take it away and go. But I am suffering. I don't get rents. But kindly see the decree, how much rent is to be paid by. But the Supreme Court in 2004 SC Atmaram Properties.
No, when the tenure has come to an end?
Beg your pardon?
Tenure has come, when the tenure, agreement tenure. Lease.
It has come to an end long time back.
Huh? 5 years ago.
But this court said it is an unregistered agreement. But the court said unregistered agreement.
2 years is unreasonable. 2 years is unreasonable. It's not a working unit. Why don't you sit across and work out at what could be the time frame for delivery of possession? Instead of court passing an order, you know the ground difficulties,
Bank
ground
or
reality is
loan,
better.
bank or the machineries or the loan are not my concern. Loans that is borrowed by him and the loans that are outstanding are his responsibility.
Understood.
And my missionaries are not subject matter of a charge with the bank.
Those things understood, sir. Why don't you work out a time frame, sit across and decide? Come out with a mutual term.
But I'll do that, my lord. My lords may have it on Monday, my lord. Tuesday, my lord, I'll see that.
Wednesday.
Please.
The question of law is raised. Delay is not.
Whether that 6 days can be condoned is a question that is being raised.
Including deposit of rents. In a commercial court matter, without deposit rents, he cannot. There is an order by this court that he must pay rent. That order is also violated by him.
The issue with my counterclaim on the ground that I could be.
All right.
That counterclaim is allowed. The rent and counter.
No, agree upon a time frame for vacating.
Prasanna Kumar, please.
Yesterday's matter, the suit for a specific performance not decreed ex parte.
Article 123. And I put word my client also. That the time frame may be kindly fixed. Anyway, that he is coming now. The time frame may be fixed for trial.
Yes, yes.
With that,
Even I would also request the same thing. She is also not 73 years. It would be in the interest of both the parties.
He may be allowed certain terms, my lord, because he has already spent the money.
There is one more development. Not the first information report that I registered. Not stands out to a different police station. Both the parties are not secured to the police station, and my handwriting samples may not have been taken with the police, which will be not subject to forensic science reports. That may take some time. So keeping that in mind, Lordship may fix a date not for disposal of the suit.
Even with regard to that handwriting, that it can be made in the before the civil court also. It is not only in the criminal courts. That even before the trial court also, it can be done.
We can also seek appointment of a private undertaking.
Please.
Don't wait for this report from the government
Of course,
department.
Madam, we'll similarly, my lord.
In the, before the civil court also that
Yes,
the.
You can move an application
can
for
be done.
appointment of
Please.
private undertaking
An
expert.
application can be made and it can be done.
That's for you to work out.
Please.
Third. This appeal is arising from the judgment and decree dated 29th January 2022. Invoice number 9397 of 2019 on the file of 25th Additional City Civil Judge, Bangalore. In terms of the impugned judgment and decree, the suit for specific performance is decreed. Full stop. Sole defendant.
Sole defendant.
The defendant is in appeal. Full stop. Along with this appeal, an application is also filed at I number 1 of 2024 to condone delay of 647 days in filing the appeal. Full stop. Learned counsel appearing for the appellant would submit that the decree passed is an ex parte decree pursuant to a notice published in a newspaper by way of a substituted service, as there was no service of notice on the appellant. It is further submission that on the date of the filing of the suit, the appellant was not residing in Bangalore, he was residing in Pune. And the endorsement would disclose that the appellant was not available in the address shown in the plaint. Full stop. Learned counsel for the respondent would submit that the notice is sent to the address mentioned in the agreement for sale executed by the defendant appellant. You are disputing the agreement?
Please, I'm disputing.
Learned counsel for the appellant has raised the contention that he has not signed the agreement and the address shown in the agreement is incorrect address.
Signatures are, I have all the original documents with me.
It is the submission of the learned counsel for the appellant that he came to know about the impugned judgment and decree after receipt of execution proceeding notice.
Please, no, I'm not, no, I did not receive any even execution notice, but I wanted to sell again. But when I go to Malad and approach the others, they say, they have obtained the EC and they say, you're now no more the owner. That happens in first week of February 2024.
February
2020.
Learned counsel for the appellant submits that he came to know about the decree in the month of February 2024. Thus, he has filed this appeal along with an application for condonation of delay. Though it is stated that there is a delay of 647 days, it is to be noticed under Article 123 of the Limitation Act. The limitation begins to run from the date of knowledge of the decree, not from the date of the decree. Stop. As it is in the case where the notice is duly served on the party. Full stop. Thus, we are of the view that when the appeal is filed?
On 7th March 2024.
Thus, we are of the view that there is no delay in filing the appeal. Full stop. Accordingly, the application at I number 1 of 2024 for condonation of delays superfluous. Full stop. Next para. Learned counsel for the appellant and respondent consented for disposal of this case. This case is taken up for disposal. Full stop. On perusal of the records, it is evident that there is no proper service of notice on the defendant appellant who was residing in Pune at the time when the suit was filed. Full stop. It is also noticed that the suit is one for a specific performance of the contract, where the appellant is now raising a contention that he has never executed an agreement for sale in favor of the plaintiff. Considering the contentions raised in the appeal memo and considering the fact that there was no proper service of notice on the appellant, without entering into the merits of the case, this court is of the view that the impugned judgment and decree are to be set aside and accordingly are set aside. The matter is remitted back to the trial court, permitting the defendant to appear before the trial court and to file the written statement. Full stop. The party shall appear before the trial court on
after 2 weeks, not any day, 2 weeks, or maybe next week also.
First of July. 1st of July.
Please.
On 1st of July, without awaiting any further notice, the defendant appellant shall file written statement within 15 days from the date of appearance before the trial court.
Please.
The trial court shall endeavor to decide the suit as expeditiously as possible. Both the parties shall cooperate for early disposal.
Please.
23, Lokesh B.
53 appears for the respondent. I request your lordship to see the order dated 5/6/2024 on the premise that the judgment and decree passed is an ex parte decree. Further proceedings has been stayed. Proceedings. And with a great respect, I would say that this court has been misled. There were two defendants in the suit. The appellants claiming to be the legal heirs of the defendant number 2. They have filed this regular first appeal. Even though their father, Chandrasekharaya, who was the defendant number 2, he was served his suit summons. He contested the suit proceedings. He filed his written statement. After a lapse of 1 year from his date of appearance, it was allowed on cost. He did not pay the cost. Later on, the judgment and decree is passed. Thereafter, his son, the third appellant, he files an application under Order 21 Rule 97 of CPC. That application came to be allowed before the executing court, and that order was challenged before this honorable court. And kindly see the order passed by this court in the petition number 46/538 of 2018. At page 4, your lordship will get it in my objections to IA, Order 41 Rule 5.
Rejected.
It was rejected because he is not claiming any independent right, title in respect to suit settled property. He was claiming the right through his father, who is the judgment debtor.
Father is alive?
Pardon?
Father is alive?
Father was very much alive. He did not utilize the statutory right of appeal at any point of time during his lifetime.
Now he is alive?
Now he is dead. Now contending that he has died on 24.
All right. When the suit against the father attained finality?
Attained finality on 21/6/2017.
21/6?
2017. Thereafter, immediately they filed an application under Order 9 Rule 3 of 13 of CPC to recall the ex parte decree. It is not an ex parte decree. Now also it is pending. Simis. They are adopting dilatory tactics. I have deposited the entire 48 lakh rupees before the trial court in 2017 itself, immediately after
No, father.
obtaining.
Date of the decree?
Date of the decree is 21/6/2017.
When father died?
Pardon?
When father died?
Father died recently in 2024, according to that.
I have produced the death certificate.
And they say that.
All right, 24.
26/3/23.
Just a second. Order 9 Rule 13 application filed by the father.
2017.
Order 9 Rule 13 application filed by the father. That is pending.
That is pending for 7 years.
All
Now
right.
they say that this is statutory appeal
Now this appeal is again by the father.
again by the legal heirs. because
Loss
after
of
his
the
death-
deceased.
Father died.
Loss of the deceased.
Now, your lordship, apex court had an occasion to consider this kind of applications and statutory, availing statutory appeal. Court said, it is not consecutively, it is simultaneous. No doubt, no doubt. A person who claims that a decree is passed ex parte against him, he has got two remedy options. One is to file an application under Order 9 Rule 13 of CPC to recall that ex parte decree, or a statutory appeal which is wider in this one. Both the options are available to him, but an unscrupulous litigant, first he may file an application under Order 9 Rule 13. He can take up the matter up to the highest forum for some 10 years. Then he can come before this honorable your lordship and say, look here, I have got a statutory right of appeal.
No. Once the one remedy is exhausted, the second remedy he can't invoke.
That is only in case where
Simultaneously he can invoke both remedies.
parallel.
One remedy attains finality, then second remedy is not permissible.
That is only in case of where this court dismisses his appeal. He cannot go back to civil court and say that consider my application Order 9 Rule 13. That is not. Whereas if Order 9 Rule 13 is dismissed, then he can file an appeal. Appeal provision is there. So therefore, the very recently Honorable High Court or Supreme Court had occasion to consider this kind of situation.
But in terms of the Supreme Court judgment, it is an ex parte decree. though he appeared, though he filed written statement, if it doesn't contest thereafter,
Yes.
it's an ex parte decree in terms of the law laid down by the Supreme Court.
No, in 40, paragraph 14, your lordship. That is the judgment rendered by Chief Justice of the Apex Court. The facts of the, I get it, 14, paragraph 14, madam. In the facts of the present case, it is accepted that the respondent corporation had accepted the interpretation. I'm sorry, madam. Not this judgment, my lord.
Order 9 Rule 13 application is filed in time.
My lord.
Order 9 Rule 13 application.
Was filed after a little delay, but we are contesting that.
Within a reasonable time.
Pardon me?
It is filed within a reasonable time. After 30 days.
I have no exact dates and all, but I'm sure that it was filed only in 2007.
What the Supreme Court says in the judgment which now cited.
14, paragraph 14, my lord. The defendant against whom an ex parte decree is passed has two options. The first question your lordship has to decide is whether the judgment and decree is an ex parte decree against the appellant or not. If that question is answered.
That question is settled even if he has filed written statement. If it doesn't contest the matter thereafter, it is an ex parte decree. Supreme Court judgment, 1986.
Defendant against whom an ex parte decree is passed has two options. First option is to file an application under Order 9 Rule 13 CPC, and second option is to file an appeal under Section 96(2) CPC. The question to be considered is whether the two options are to be exercised simultaneously or can also be exercised consecutively. An unscrupulous litigant may, of course, firstly file an application under Order 9 Rule 13 CPC and carry the matter up to the highest forum. Thereafter may opt to file appeal under Section 96(2) of CPC, challenging the ex parte decree. In that event, considerable time would be lost for the plaintiff. The question falling for consideration is that whether the remedies provided as simultaneous can be converted into consecutive remedies. An appeal under Section 96(2) of CPC is a statutory right. The defendant cannot be deprived of the statutory right of remedy merely on the ground that earlier the application filed under Order 9 Rule 13 CPC was dismissed. Whether the defendant has adopted dilatory tactics or whether there is a lack of bona fide in pursuing the remedy of appeal under Section 96(2) of the Code has to be considered, depending upon the facts and circumstances of each case. In case the court is satisfied that the defendant has adopted dilatory tactics or where there is lack of bona fide, the court may decline to condone the delay in filing the first appeal under Section 96(1). This is the test that has been applied by the Apex Court, my lord. Your lordship may kindly see the memorandum of appeal also. They admit that they have contested the matter. Even in the memorandum of appeal.
No. Have they cross-examined the plaintiff?
They have not, because what has happened, my lord? The father has gifted the property to his son.
Understood.
That is
they have not cross-examined.
They have not cross-examined
in
spite of granting opportunities.
So technically it becomes an ex parte decree in terms of the law laid down by the Supreme Court.
Now, insofar as the language employed under Section Order 9 Rule 13, it is only in respect of service of summons, not on other things. I will not go into the other aspects of the matter. Now, whether the litigant can be permitted to conduct parallel proceedings simultaneously.
No, that is permissible in terms of the law.
That is permissible, provided your lordship condones the delay of 7 years. 7 years delay is here. It is not that he is not unaware of the decree.
See, Order 9 Rule 13 proceeding is also not decided on merit as expeditiously as it was expected.
He is responsible for it. He is responsible for it. I am not responsible for it. Having approached the trial court stating that this is an ex parte decree, he has taken this much of time. And he is fully aware of the execution proceedings. He has obstructed the execution proceedings. Application was allowed, and he was also a party to this writ petition. And there is a writ of mandamus was filed by me directing the executing court to proceed the matter expeditiously.
Decree for specific performance.
suit for this.
Suit.
Original owner, he never appeared before the court. He was placed ex parte. Original owner who entered into agreement with me, he was placed ex parte, not the father of the appellants. Because suit summons was served.
Original owner is defendant number 1.
Defendant number 1. He is the original owner who had entered into agreement of sale.
Who is defendant number 2?
Defendant number 2 is Chandrasekharaya.
Purchaser.
He is the
All right. Why is he made a party?
because he purchased the property much before I could come before the court in order to defeat my rights.
No, all right. He is a purchaser before you filed the suit.
Before he filed that suit.
All right. Your agreement is registered agreement.
It was not a registered agreement. He had
So,
received 5 lakh rupees.
All right. The contention that he is a bona fide purchaser is allowable to the prior purchaser.
The trial court has held that he is not a bona fide purchaser for value.
No, because there is no contest.
I was not contested.
Contest in the sense, if a person who has received
No,
the
no,
suit.
what we are saying, loud thinking, you are not formed any opinion. What we are saying is, at the end of the day, it's an ex parte decree.
Yes, my lord.
If there is lapse on his part, we can impose some cost on him.
Now, what will happen to me? 7 years I've waited, I've invested 50 lakh rupees, I've deposited before the executing
For
court.
this reason, we will impose some cost.
Now, if the entire decree is, in addition to that, on the strength of the gift deed executed by his father, appellant number 3 has instituted suit against me. One more suit, multiple proceedings.
Now, of course, it is this.
As on the date of filing the suit, Dhoni was the owner of the property. He was not made as a party.
Case. Forget about the second suit. It is not your case that you are an agreement holder with possession. Now, in execution proceeding, you are seeking possession, right?
Yes, my lord.
You're not contending that you're an agreement holder with possession.
No.
So you're not in possession.
I'm not in
Possession has-
possession.
So possession has to be delivered to you.
Yes, has to be.
We'll impose- No, we can notice,
Registered sale deed at all,
we
as
can-
of today.
we can notice that there is some lapse on the part of the appellant. We'll
Not
impose,
some, my lord,
Right, we'll-
not some. I can understand. I have no objection in going ahead with the matter. Here is a case where there must be a lifespan for every litigation. If the delay of 7 years is going to be condoned on the ground that this is an ex parte decree, when the parties are fully aware that there is a judgment and decree.
so it's quite possible, assuming that we are not condoning the delay. That means we are not allowed the appeal on merits, considered the appeal on merit. If the application is dismissed on the ground of delay,
There is a delay.
then Order 9 Rule 13 application can be prosecuted. Only in case of appeal is dismissed on merit, Order 9 Rule 13 becomes infructuous.
It is for.
If you are saying that the Order 9 Rule 13 application is pending, he has not filed this appeal diligently, we are only dismissing the application.
Premature.
So there is no confirmation of decree on merit. So Order 9 Rule 13 application can be prosecuted.
Let him prosecute. I have no.
Even
Again,
after dismissal of the
He
sentence,
cannot,
he
he
will come
cannot,
here.
he cannot simultaneously come high court as well as the trial court. A litigant is not permitted to conduct parallel litigation in respect to the same subject matter. There also the remedy is to set aside the judgment and decree on a short ground. Here also the same remedy. Can a litigant be permitted to avail a remedy as and when he likes? There must be a lifespan for every litigation. I may not be obliged to see the fruitfulness of the decree after 10 years or 15 years.
What is the stage now in Order 9 Rule 13 application? Delay is already condoned.
Arguments.
It is posted for
Delay is not
arguments.
condoned.
Final argument.
LR application is pending, my lord. They have seriously resisting the LR application filed
No,
by
we
the
are not.
appellants.
Yeah, cross-examined
Just-
the
Trial is over there.
trial is
Trial is
almost
over.
over, now posted for arguments.
No. LR application is pending. I have filed an application. It is on hearing on IA. Instead of pursuing the Order 9 Rule 13, if an
Just a second. LR application after the trial is concluded,
yes, my
when
lord.
it is filed.
Immediately after the death of my father.
No, are you seriously objecting the LR application?
No, absolutely. I am
No,
not a person to
To
object.
pursue that Order 9 Rule 13 remedy, we'll make it clear that notwithstanding the dismissal of this appeal on account of
Yeah, please,
delay,
my lord.
the party shall,
Why I am filing this appeal before this honorable court is, earlier my father was filed. My father was filed a miscellaneous petition.
correct.
This, the LRs of the deceased, they are not aware of
You
the
are
earlier
claiming to your
proceedings.
father. You don't have an independent right. You are claiming through your father.
Yes, yes, my lord. After the death of my father only, I come up with this appeal only to, not only on the service of notice, mainly on the main grounds on appeal, my lord. The scope of the appeal as
Understood,
well as
but
the
for that-
miscellaneous petitions.
For that, you have to explain delay for 7 years.
Earlier, I have produced submitted the one judgment of Punjab High Court, my lord. On the guise of earlier applications, Order 9 Rule 13, when it is pending, appeal can be filed.
Appeal is maintainable, no
filed.
difficulty.
Would have been filed in
Please, ma'am.
time. Why
Please,
after
please, ma'am.
7 years?
I can pursue that one also.
The apex court says, Your Lordship.
Order 9 Rule 13, it may be disposed of.
What you are saying is, appeal is maintainable, no difficulty.
No.
But there is delay of 7 years in filing the appeal.
Which you
Delay is
have
not properly explained.
Delay was due to the pendency of the Order 9 Rule 13,
that
because
cannot-
of my
That can't,
father.
that can't be the reason.
Kindly see paragraph 9 of the judgment, my lord, insofar as delay is concerned, the approach of the Supreme Court, my lord. The doctrine of delay and laches are for that matter statutes of limitation are considered to be statutes of repose and statutes of peace, though some contrary opinions have been expressed. The courts have expressed the view that the law of limitation rests on the foundation of greater public interest for 3 reasons, namely, that long and dormant claims have more of reality than justice in them. That a defendant might have lost the evidence to disapprove a stale claim. That persons with good causes of action who are able to enforce them should pursue them with reasonable diligence. Equally, change in the de facto position or character, creation of third-party rights over a period of time, waiver, acquiescence, and need to ensure certitude of dealings are equitable public policy consideration. Why period of limitation is prescribed by law. Law of limitation does not apply to writ proceedings, albeit discretion vested with the Constitutional Court is exercised with caution, as delay and laches principle is applied with the aim to secure the quiet of the community, suppress fraud and perjury, and quicken diligence to prevent oppression. Therefore, some decisions and judgments do not look upon pleas of delay and laches with favor, especially and rightly in cases where the person suffers from adaptness or incapacity to approach the courts for relief. However, other decisions, while accepting the rules of limitation as well as delay and laches, have observed that such rules are not meant to destroy the rights of the parties, but serve a larger public interest and are founded
Sir,
on
understood.
public policy.
Sir, understood.
There must be a lifespan during which a person must approach the court for remedy. This is what-
Understood.
Yeah.
Now, if you are dismissing this application for condonation of delay, since you have said that the evidence is already over, it's set down for argument, and you are not objecting his LR application.
Yes.
What we will say is, let the trial court dispose of the Order 9 Rule 13 application within 45 days or 30 days, whatever. Until then, don't execute the decree.
Not a prosecutor.
That would have,
Till then, only for a month, that's all. Yes. Heard the learned counsel appearing.
even my lord, they should have made an effort in this to secure an order for calling the execution process. That they did not do.
All right.
I was forced to approach this court by filing a writ petition, seeking a writ of mandamus to the executing court, and that order was also allowed down.
No.
By virtue of this order, stay, my lord. My lord has virtually staying the orders passed by this court. Learned single judges,
Heard
which went unchallenged.
Heard the learned advocate appearing for the appellant as well as the learned counsel appearing for the respondent. With the consent of the this appeal is arising from the judgment and decree invoice number 45 of 2015 on the file of Senior Civil Judge Chennaraipatna.
Yes.
Chennaraipatna. In terms of the said judgment and decree, the suit for specific performance of contract is decreed. Full stop. The plaintiff claims that he had entered into an agreement with first defendant. And the defendant number 2 claims to have purchased the property from defendant number 1 prior to the filing of the suit. Full stop. Before the trial court, the defendant number 1 remained ex parte. Defendant number 2 did appear while it did appear
Technically
while
contending in appeal. Written statement was also filed.
while written statement. However, the
Cost was imposed.
however, the defendant did not cross-examine the plaintiff and did not lead evidence. Full stop. Consequently, the impugned judgment and decree are passed. Full stop. The defendant number 1 then filed an application under Order 9, Rule 13 of the Code of Civil Procedure to set aside the decree on the premise.
Two.
Sorry, different number two, on the premise that the decree is an ex parte. Said the proceeding is still pending before the senior civil judge, Chennai Patna. After lapse of, as the defendant number two died in the 2024, right?
26/3/23. Died on 26/3/23.
26/3/2023.
They have filed applications on 5/6/2023.
The
LRs.
legal representatives of defendant number two have filed an application before the trial court to pursue the application under Order 9, Rule 13 of the Code of Civil Procedure, which was filed by defendant number two. Full stop. Thereafter, on 5/5/2024, the present appeal is filed by the legal representatives of deceased defendant number two. Full stop. As already noticed, there is a delay of 1,000.
7 years.
No.
How many days?
The decree was passed on 21/6/2020.
Yeah, as per the code,
1704.
1,704
COVID though, COVID is
exempted.
There was no COVID, no question of seeking any exemption.
There is a delay of
704.
7 years.
No.
1704 days.
1704.
No, there, according to their own state, the application under section 5, it is 2,325.
No,
No,
sir.
no, Allah.
It is-
The court has rectified this.
Court,
Rectified.
COVID then ಬರುತ್ತೆ.
Court has exempted the COVID period.
ಅಲ್ಲ, exemption ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
Hardly 1,704 days delay in filing.
My lord, it is wrong. The benefit of COVID, this one. put
Nearly 7 years. Nearly 7 years. There's a delay of nearly 7 years in filing the appeal. Full stop. We have considered the grounds urged in the application seeking condonation of delay. Full stop. The appellants have urged that since their father was prosecuting the proceeding before the trial court by invoking Order 9, Rule 13 of the Code of Civil Procedure, they were not aware of the procedure. They did not deem it appropriate to file appeal under Section 96 of the Code of Civil Procedure. Full stop. Learned counsel for the respondent has taken us to the averments made in the application for condonation of delay, affidavit accompanying application for condonation of delay, and would contend that the delay is not properly explained. Full stop. It is to be noticed that the application to set aside the ex parte decree was filed in the year 2018.
18.
2018.
Yeah.
2017 itself.
Execution.
For close to 7 years, the present appeal is not filed. It is a well settled principle of law that both remedies are available to the party who has suffered an ex parte decree. That is to say, to move an application under Order 9, Rule 13, and also to file an appeal under Section 96 of the Code of Civil Procedure. Full stop. It is brought to the notice of this. It is urged before this court that after having filed the application under Order 9, Rule 13 of the Code of Civil Procedure, the applicant before the trial court did not prosecute the matter diligently and kept on seeking adjournment. Full stop. There is nothing on record to show that the appellant has exercised due diligence in prosecuting Order 9, Rule 13 application, where he has sought to set aside the ex parte decree. Under these circumstances, this could be the view that justifiable grounds are not made out in an application under Section 5 to condone the delay in filing the appeal. Accordingly, the delay of nearly 7 years is not condoned and application is dismissed. Next para. It is made clear that we have not considered the appeal on merit since an application is filed before the trial court under Order 9, Rule 13 CPC and same is pending consideration. The trial court is directed to dispose of the said application on merit without being influenced by the dismissal of the present application. We make it clear that the application is maintainable before the trial court, and it is also submitted that the by the learned counsel for the respondent that he has no objection to the legal LR application filed before the trial court, and same shall be allowed. Full stop. Since it is brought to the notice of the court that the trial has already concluded, the trial court shall endeavor to dispose of the application under Order 9, Rule 13 on its merits within 45 days from today, full stop. It is further made clear that till the disposal of the said proceeding, the respondent shall not execute the decree.
Till the disposal of.
Till the disposal of that application. Till the disposal of that.
application.
And they have also filed an application under order 21 rule 97 once again.
Yeah, of course, of course.
The second application they have filed.
No, you are not proceeding now. You are not proceeding.
Lordship, I will
Till the
tie my
disposal,
hands.
only 45 days.
Please, man.
No, you are not tied your hands, you have passed an order.
At least for the.
Disposal.
Because my lord, what has happened? Writ of mandamus.
Now your deposit is in the bank.
No, it is in court. Now the problem, what has happened is they are sending the money to the government treasury. Even to take our
No,
money.
Make a request, you want it to be refunded to you? Can pass an order, or we can,
Kindly.
no, we'll pass an order to deposit the amount in bank.
That question,
That
the
order
presiding-
can be passed because
No, for
neither
deposit-
I will be able to enjoy the
Right.
fruits of the decree.
It is to be
Nor
deposited,
my money will be wasted.
it is deposited in bank.
It is deposited before the court.
No, you want it to be deposited in bank now.
In bank.
My lord, on the last date of, before trial court has expressed the same thing.
It is
Requested to
submitted by the
deposit in
internet
FD or return the same.
Respondent that the respondent has already deposited the amount in terms of the decree passed by the trial court before the executing court. The amount deposited by the decree holder shall be kept in a nationalized bank in a fixed deposit with the auto renewal mandate. For a period of 2 years. The condition is dismissed.
Four, Satish K.
Respondent. Remote was granted without hearing the caveator on that ground it's met.
No, this caveat is filed, no? Caveat was filed without hearing the caveator, it was because that day, my lord, nobody appeared for caveat.
Election duty.
But I am on election duty.
Over now.
Right?
Is that not over now?
No. As far as the accounts is concerned, it will be there after 34 days. I have produced the election instruction
has been-
last occasion.
Let's hear it on merits.
Yes, ma'am. That's what on the last occasion, my lord, he has
Occasion.
submitted,
Already.
it's a February order, February 1st order. I assume the chairman of status quo order has passed. To avoid my lord confrontation, my lord, he is working, my lord.
Last
Pass over.
occasion.
He's a
my lord,
deputy director, I'm joint director.
Pass over. Can be heard today.
Not take then more than 5 minutes, my lord.
but, I'm ready, no doubt, but if
No, he
passed
has-
over, my lord,
We'll just go through the list and
No.
get back to you after the admission.
it may be a call next week then.
No,
because
no, please, no. Since
I-
April, my lord,
One
he is,
minute. I'm ready now, my lord. Only if it is passed over, my lord, I may be held up in.
will
other
not
part
take
of my-
more than 5 minutes, my lord.
No difficulty,
He's a
lord.
senior advocate, he can complete within 2.5 minutes. I can finish with not more than 5 minutes.
But for
He's a
him,
deputy director holding the post of joint director.
for him, my lord,
He is aware that, my lord, it is a joint director post. In the petition, my lord, he is misled that there is no sanction of joint director. I produced the government order. He is aware of that government order. He misled the tribunal, therefore, my lord, status quo order passed. After producing my government order, my lord, the case was dismissed. Here now says that there is an election matter on that ground, my lord, even though he is aware that, my lord,
but he was a caveator.
caveator, my lord, because
My lord,
I mentioned last
he-
occasion by mistake of the office, my lord,
By
my name is
planting in the
wrongly
order,
typed,
he
my lord, I
never
could not.
came, my lord. What passed you?
He is aware that, my lord, I am a caveator. He is not informed to me, my lord. He is aware that, my lord, date of hearing.
Yes, pass over.
For Passover, some difficulty, my lord, if I'm held up in other matters, my lord.
Satish is argued, my lord, and earlier he is, it is not that, there is
I
no
am
other
engaged-
ground, except election, my lord, there is no other ground.
I am engaged, my lord, I am making this, otherwise, my lord,
It may be called next week, my lord, I will argue.
No, please, my lord, because my lord, since my lord, February, my lord, he assumed the charge. On that ground, my status order is passed. To avoid confrontation, my lord, I informed my client that he need not.
The respondents today.
Yes, my lord.
I leave it.
Admission.
Otherwise, I will argue now itself. I will not take.
Yes, he is here.
Go through the list and come back.
Please.
Admission, number 25.
My lord, I appear for the respondent, my lord.
For the appellant, Your Honor, I am for the
Ejectment
so
and
ejectment,
arrears.
suit is for ejectment. I am the defendant in the trial court, my lordship. And I am the tenant. As per I have two contention, my lordship. First one is, at the time of entering into the agreement, it is a vacant land, 40/60 vacant land.
You constructed the.
Yes, I constructed, and at the time of I entering the lease deed, I have paid advance of rupees 7 lakh rupees. I have paid, my lordship. But what I have invested from the exhibit D4 to D74 bills and what are the memos what I have invested, but the trial court is not considered the documents, my lordship. And another one thing is, he is come before this court like that. He is a owner, absolute owner, but he is a GPA holder of his mother. But at the time of cross-examination of the PW1 only, he adduced that I am the GPA holder of my mother. Till date, it is suppressed the facts before the court. After that also, he is not produced the GPA. And subsequently, his mother also died, my lordship, and the GPA also expired. But the trial court is not appreciated that these things, my lordship. And in trial court, 3,50,000 I have paid, and on 7/6/2024, in execution court, I have paid 3 lakhs rupees, my lordship.
May I make a submission?
And there is a confusion in that. And there is a confusion also, my lordship. There is a two agreement is there.
Property belongs to him.
Property belongs to his
You
mother. He is a
entered into an agreement of lease. Term has come to an end.
Nothing else
but
is
orally it is action.
So in a case
All these
like this,
contentions appear to have been considered also.
And there is a dispute that there is a two agreement. First is also executed by same thing, same person, and it is for 40,000. And secondly, it is created, and that one also not produced before the trial court, my lordship.
First of
I
all,
have produced.
which is the agreement?
Yes,
Para
my
32,
lordship.
my lord. Para 32 is very clear.
There is a two.
He has admitted the agreement.
Two agreement. First, what he executed, that is proper only, my lordship. But what happened after got NOC from the trial court, it is found that it is these things, and I have after completion of the written statement only, I seen these things and preferred for this.
Yes.
so in a case like this, ideally you should persuade the landlord to extend the time rather than arguing the matter before the court.
I am ready to abide any conditions also, my lordship.
No, have a discussion, give him a reasonable time.
Your lordship may decide it, my lord. There is no difficulty.
No.
Your lordship may grant a 3 months time, my lord. No doubt we have filed execution petition, my lord, indicating.
What is the business he's carrying out?
It is like Kaveri Silk Emporiums. Kaveri Silk Emporium, silks and crafts items are selling this.
You have stated that you have got one more shop in the same street.
It is stated that not I, who is the defendant, nearest my property, that is his property only, he have another one.
Not the
business.
You are the defendant.
You are the defendant.
Yes, sir. Sorry, plaintiff.
He has got that.
I think your contention that you have got one more shop.
One more shop.
So both of you sit across and decide on a time frame. Pick your client.
My submission would be 3 months
No,
time.
Instead of we imposing anything,
Yes.
both of you agree upon.
Well. Pass over.
Pass over.
26, Ajit.
This matter. In this matter, this is. In this matter, one submission made. The respondents also filed the appeal. So that has also put up along with this.
But I have sought for interim order, Your Lordship may kindly recollect this. Your Lordship has already called for the records in this matter. And I requested this Honorable Court to grant an interim order. My learned friend was not present last time because he's a cavator. But Your Lordship said, let be posted here and it will be considered. My request is.
It is cancelled.
Pardon, Madam.
Joint development agreement is cancelled.
Yes, madam. Now the question is, under the joint development agreement, there is a specific clause.
have also
It is
filed
not,
the
it is
appeal.
not revocable. There
Therefore,
are
the
two
court
things.
along with-
The joint development, the view of this Honorable Court, if the joint development agreement along with the coupled with interest, it cannot be revoked at all. The remedy is only for damages. In this particular case, joint development with coupled with interest, you have paid the amount that is mentioned in the joint development agreement. And more specially, there is a specific clause. It cannot be revoked. Remedy is only for claiming damages. 2 rupees per square feet in respect of the constructed area. It is in respect of construction of an apartment. But the joint development agreement is also very clear to that effect. What happened was when we entered into joint development agreement, the term was 5 months. Within 5 months, we have to.
Now there is one more appeal.
Yes, madam.
Now your apprehension is likely to execute the decree and sell the
Where's
property.
Not only that, but now we came to know that they are trying to, they are started leveling the land and also entering into the third party's interest. Let him not.
JDA was cancelled.
Your appeal will be listed. Your appeal will be listed along with
ನಾನು
this.
ಡೇಟ್ ಹಾಕಿದ್ನ ನಿಮ್ಗೆ ಕಳ್ಸಿದ್ದೀನಿ ನೋಡಿ.
Till then, don't carry out any work. Don't create any third party
Yes,
right.
ma'am.
We will-
The JDA was cancelled. Only the counterclaim has been allowed. So that was I have challenged before the commercial court as well as this.
No, understood. We'll-
Commercial court was dismissed by both the appeals.
Both appeals will be listed. Till then, don't create any third party charge.
Now, that has been already created. The
Further.
JDA has already, before filing the commercial appeal itself, it has been already cancelled and on the order of the tribunal itself. So any date kindly post along with my appeal also. any
Let
date
him,
may be
let
considered.
him not.
So I am
create
ready.
The reason is this.
I am
Lord.
ready.
I have taken the sanction plan. Construction of apartments.
No, that is all.
Yes, sir.
So
Third party right is
not
already created.
So even filing of plan
Sir,
itself
that is-
has been rejected by the tribunal.
Don't put up any structure till next day. Don't put up any structure till next day.
But-
We will hear both the cases.
There was a status co order by the commercial court. There was a status co order granted by the commercial court.
Only regarding counterclaim is allowed. So that was challenged.
This challenge by me.
So as per the conditions of the JDA as well as MOU, the tribunal has been finding clear saying that the conditions are not been fulfilled by the developer. So I am since 2013, this is the 11th year, he has not, so single word he has saying that we will perform the contract about the MOU as well as the JDA. So the rejected the MOU, JDA and GPA by the tribunal. So counterclaim has been allowed. So that was challenged before the commercial court as which was dismissed by both the appeals and come before this court.
Counterclaim is for refund of 65 lakhs.
Some money,
Counterclaim
some money.
is for
65
damages. Alternative.
Some money. That is also not entitled to them.
Section
I
22.
place on record, my lord.
Section 22 is very clear. Unless we seek.
My appeal, I
refund of
have
amount.
produced all the documents.
But the reason is, 5 months time was fixed. We could not do it because of the NGT order. And we have, the NGT, we filed an application, sanction plan before the competent authorities. They have returned our plan on the ground that there is an NGT order. You have to leave 50 meters from the Raj Kalwe. Then we have requested him, you accept for this and we will construct the building. He refused. Then, my lord, it was went to the Honorable Supreme Court. Supreme Court has clarified it. That order is not applicable. Immediately, very next day, we applied for pursuing the plan. He opposed for sanctioning of the plan. Plan is very much available. Now they are taking advantage of that. No, my lord, he is getting that plan sanctioned, giving it to somebody else. Let them.
We will list your matter next week along with this matter.
Yes, ma'am.
Till then, status quo.
Please, so kindly see the inquest 179 may have kindly.
Yes.
In his appeal. The impugned order.
Understood, yes. Yes.
So the JDA and the GP has been cancelled.
No,
The
that's not a
counter
challenge,
play-
sir.
This
That's
is
not
a
a challenge
challenge
now.
to the appeal. They're considering the appeal as well as yours.
So
Next week.
the only, with
Or the
regard to,
learned-
he claimed himself as counterclaim, while filing the statement
Heard
of.
the learned senior counsel appearing for the appellant as well as the learned
No,
counsel.
it has
appearing for the
already been.
Respondent, learned counsel for the respondent submits that he has also filed an appeal in commercial appeal number
190 of 2020,
190 of
190,
190 of 2024,
24.
2024, full stop. Since both appeals are arising from the same order, both appeals are to be listed together, full stop. Next paragraph. In terms of the award passed by the learned arbitrator, the joint development agreement entered into between the appellant and the respondent as well as the general power of attorney are cancelled. Learned senior counsel for the appellant would submit that the general power of attorney executed is an power of attorney coupled with interest and could not have been cancelled at all. Stop. Learned counsel for the respondent would submit that the appellant did not adhere to the terms of the contract within the time stipulated, and no case is made out to entertain an appeal under section 37 of the Arbitration and Conciliation Act 1996. Having considered the materials on record and also considering the fact that there is one more appeal filed by the respondent, this put in the view that there shall not be any construction till next date. And
Only regarding construction.
only regarding
Construction.
construction.
Because.
Construction and alienation also. But if they start
He
alienating.
says, no, he says
So it has
already entered into an agreement.
Yes.
No, that
Construction.
that cannot be
construction.
because there is an interim order.
He
by the-
says so. He says so.
So, Your Lordship may kindly
All right, I will record his statement till next date. This matter. One sentence. Learned counsel for the respondent submits that the respondent has already entered into one more joint development agreement. When?
Date.
Immediately after the award, huh?
Yes, ma'am.
Immediately after the award passed by the arbitrator. Arbitrator. Date could be.
And
Both-
Now, let the copy be.
also cancelled by the sub-registrar on the directions of the tribunal itself.
Let him serve the copy on the
Yes.
advocate.
Yes,
Date.
Now itself.
28.
20. 27.
Let the copy be served on the.
27, huh?
Yes, any date can be.
27.
28.
28.
28.
Please.
I may permitted to.
Twenty-seven, Raghavendra.
For the respondents. On the previous occasion, I had sought 2 weeks' time to file my objections to IA number 1 and 2. But the documents with respect to IA number 1 was served on me only on Tuesday. So I'm requesting for another 1 week time, my lords, for me to file my objections.
I'll make, Lordship permits, I'll make it a case for admission. Then,
Well,
they
no
can proceed
execution
with.
case has also been filed as on date, so there'll be no prejudice, only 1 week's time. I'm requesting.
No execution.
No execution.
I don't have, I only have to make it a case for admission, probably for sending it back. Because my lords, I'll be able to show your lordships that it's an absolutely non-speaking order. That's all that's the only time I require. They can file their objections in due
Does
course. I don't have any objections to what they say.
This is section 37 or original suit?
34.
Original.
The original suit.
Original
13.
suit appeal.
Appeal.
You're not seeking any interim order.
I would be seeking if
He has not yet filed execution, right?
Not yet.
Then my lords, I'll just only show your lordships what the issue is. And if lordships is convinced, the LCR may be taken and then the
Call for records.
call for records. And if it is to be sent back, it can be sent back. Or my lords may hear it and dispose it.
You file statement of objection, you call for records in the meantime.
Please.
This could be issued, my lord.
The
Last time I
reason
think
is
notice was
the
not issued.
documents what they're seeking to rely upon is between a company named Prefect Hydraulics Private Limited.
I'm sorry, I think he was in caveat. That is right.
No,
I
I
think
filed
he was
my
in-
wakalat as well.
Learned counsel for the respondent cavator accepts notice.
No, they've already accepted notice, they've already filed wakalat as well.
Learned counsel for the respondent cavator seeks short accommodation to file objection to the application seeking production of additional document. 2 weeks time granted. In the meantime, call for records.
My lords, and his statement may be recorded that he is not going for execution.
It is further stated that execution petition is not yet filed and it won't be filed till next date.
Please, deeply obliged.
Twenty-eight, Sadashivaya.
For the respondent is filing a statement objections. Short accommodation, not able to secure the accounts. Appearing. Statement objections.
Yes,
Filing statement objections.
statement,
Statement objection to IM.
which I,
13 enrollment.
My lord, as such, my lord, there was an interim order before the trial court. And thereafter, my lord, it was vacated and appeal failed to be filed before this court. In this appeal, the interim order was granted till the disposal of this.
just a second. Evidence is recorded in this case.
Yes, ma'am.
The case was set down for final argument. You filed application on Order 7 Rule 11.
Please, ma'am.
Application is allowed by analyzing the evidence on record. Without considering the issues, by analyzing the evidence on record, application under Order 7 Rule 11 is allowed. That's
Yes,
impermissible.
There are several judgments. Anytime you can file application order 7.
Anytime it can be filed, but what is taken into consideration is the evidence on record, not the plaintiff government.
One relevant portion I wanted to.
See, it could have decided the
No, no.
application.
Only the trial court has considered only an application, not in merits on.
No,
Evidence.
it has looked into the evidence. It has
Evidence
given
has been-
finding. It gives a finding that you are not the owner. Plaintiff is not the owner.
No. Even he himself has admitted fact that
Those things,
he filed a form number 7A application. He himself,
sir, understood. Those things could have been considered if the case was heard on merits, one aspect.
Yes.
If the court is considering only Order 7 Rule 11 application, its scope is extremely narrow. It has to see whether the suit is barred by limitation under Order 7 Rule
Yes.
11D.
Yes.
That is your case. It is barred by limitation. It says it's barred by limitation by looking into the evidence. What can be considered is plain government. Look at prayer A. It's only, he seeks a declaration that he is the owner and he is in possession.
no,
That
he
prayer is not barred by limitation, prima facie.
he is not in a position of the property.
And
From
further,
the date of 1985 till today,
Item number 4 issue of the at page 41, my lord.
Yes. Second prayer is relating to the cancellation of or the declaration that the gift deed is not binding. He is not a party to the gift deed. So even without second prayer, if the first prayer is maintainable, it has decided on merits after considering the evidence.
he
This is
himself
already let in.
is not to declare only sought for relief of only declared relief. Is not in, is not seek for position also. My.
So those things on merits, sir.
His contention
If the
that
court
he is
has,
in possession.
yes, he seeks a declaration that he is in possession.
His contention is that he is in possession. Why should he seek
No.
possession?
Since
is
from
his con-
1985, I am in possession of the
Therefore,
property.
if that is
This
his
respondent,
contention,
we are in possession of the property since from the date of 1985.
But tell us, from the argument made in the plaint, how the suit is barred.
per se, that is how it has to be considered. Not from the evidence.
Maybe you are having good case on merit. We are not saying that. The exercise is
2013
wrong.
suit. 2013 suit. Evidence already recorded.
Prior to that also.
No, probably by this time you would have had a degree on merits.
Exactly.
ಏನ್ ಮಾಡೋಣ? In fact, they were shown in the cause of action in the year 2006.
No. What they say is, in the 2006, we came to know there was a
Knowledge of the,
there was a gift deed. For that, probably the claim is time barred. But for prayer A, declaration that he is the owner. So the gifted is not a party.
This filed in year 2007, 3 number is 2013.
The gifted is not a party. They can ignore the gift deed. It has to be considered on merits. Evidence is already led. Not a case made out for rejecting the print under Order 7 Rule 11.
On short accommodation.
Issue number 4 may also be next. Till such time, my lord, let him not alienate property because, my lord, by virtue of the documents, my lord, he is claimed.
Heard the learned counsel appearing for the.
ಅಲ್ಲ ಎಲ್ನೇಟ್ ಅವ್ರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ನನಗೂ ನಾಲೆಡ್ಜ್ ಇಲ್ಲ 31/5/2000 ಲಾಸ್ಟ್ ಮಂತ್ ಮೇನ್ ಎಲಿನೇಷನ್ ಆಗೋಗಿದೆ.
Elimination ಆಗ್ಬಿಟ್ಟಿದೆಯಾ? When?
31/5/2024 ಅಲ್ಲ.
During the pendency of this appeal.
ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದ ಅಪೀಲ್ ಪೋಸ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ. ಪೋಸ್ಟ್ ಅಪೀಲ್ ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ನಾಲೆಡ್ಜೇ ಇರಲಿಲ್ಲ ಅಪೀಲ್ ಆಗಿ. We are not knowledge of the appeal.
No, during the pendency of this appeal.
You have not knowledge of this appeal till ನಾನು ರಿಸೀವ್ ಮಾಡಿದ ಕಾಪಿ.
Knowledge is not the criteria.
I am received copy on 5/6 only.
Pendency is the criteria.
Pendency is they have filed appeal but they have not proceeded appeal. The appeal is pending. But they have not received the appeal memo or any copy.
That alienation is subject to the result of this case. Heard the learned counsel appearing for the appellant and respondent. Learned counsel appearing for the respondent seeks short accommodation. At this juncture, learned counsel for the appellant submits that there is a threat of alienation of the suit scheduled property. Learned counsel for the respondent submits that the suit scheduled property or property na suit scheduled properties are sold during the pendency of this appeal. Full stop. Till next date, there shall not be any further alienation. If any alienation has taken place during the pendency of this appeal, there shall be subject to the final outcome of the appeal. Next week, which date?
Please.
Which date?
Next week, 2 weeks.
28th.
28 ಬೇಡ 30th 31st 28 ಬೇಡ.
First week of July. 4th. Twenty-nine, Manu Prabhakar Kulkarni.
Please, ma'am. Lord, I challenged my lords.
Yes. Binding term sheet.
But I was the claimant in arbitration proceedings. The respondent files an application under section 16 contending that there is no contract at all. What the parties agreed and signed on was a pre-contractual document. It was not binding on the parties. It is in that very document that there is an arbitration clause. Not I, the claimants, contended before the arbitral tribunal that there is a valid contract and therefore a valid arbitration agreement tucked into that contract. The respondent in that arbitration contended that there is no contract and therefore there is no arbitration clause. The arbitral tribunal, my lords, gives, in my respectful submission, an inconsistent decision that there is no contract entered into between the parties, but the arbitration clause, which is part of the very same contract, is nonetheless binding on the parties. Therefore, my lords, I filed a petition under section 34. The respondent also filed saying that costs should not have been imposed on him because he ultimately succeeded in the arbitration. Both the petitions were heard, both were dismissed. Both of us have filed appeals. Lords, my principal submission is that this is an inherently contradictory finding. Either a contract will stand or a contract will fall together. And my lords, on that point, I also cited authority which the honorable judge notes, but does not, in my respectful submission, appreciate correct.
There is another appeal. There is another appeal?
There is another appeal. There is another
Admitted?
appeal.
The other appeal is admitted?
No, my lords, it's not admitted. It came during vacation. It is not yet admitted. This is the.
Both will be listed together.
Please. Page 2, my lords, are the details of the appeal.
Next hearing date is fixed in that case, 12 to 2020.
No, my lords, it only says list this matter after summer vacation.
Tentative date,
Tentative date.
12 to 2020.
Date is 12 to
I'm so sorry, my lords, that's
2026. Computer generated. But probably it is not
Session.
correct. Just
short
today.
point, my lords, any date.
List this matter along with law map number 166 of 2020.
6/8. Wonderful.
Great.
Thirty.
For the caveat arrest.
Lord defendant's appeal in a suit for partition that
Before the
is filed.
learned,
Great.
sorry to interrupt,
Yes.
before the learned senior counsel commences, there are 4 other appeals, my lords, against the same judgment and decree. If all can be connected and heard together.
But those have not yet come up. So I mean, I can't wait for those to come up when they will come up. I'm only asking for a stay of the execution.
My lords, another
Partition
appeal
decree.
was not a part,
FDP is initiated.
Not
not
yet.
yet, because
No,
in
but your
another
lordship
appeal.
sees, just like this earlier matter, I don't know about whether the appeal was filed or not. I have sold it, the previous matter before item 28. I mean, he's got a good, bad or indifferent, he has a decree in his
You are the
favor.
defendant.
I'm the defendant. No, what has happened is,
So you are not seeking injunction, you are seeking stay.
I'm seeking for stay.
Final decree proceeding can go on.
No, not yet been filed. I'm only asking for stay of the judgment and decree. The
Drawing
only
of final
reason,
decree.
the reason is this, in 1974, there is a registered partition deed.
Notice the drawing of final decree can be stayed, nothing else.
Very well.
Let's, may I submit this one? In another appeal, was not a party to the original suit. That has been filed in April and an interim order has been obtained. In fact, in his own appeal memorandum, he has given a family tree wherein that person is not a party of our family. He has already obtained a stay. Therefore, my humble request.
Stay of what?
Stay of the, he has sought leave to file the appeal and stay of the
Entire decree.
itself.
Entire decree is stayed.
Yes, yes. Entire decree is stayed. In fact, even though he confines.
Record his statement. Same decree is stayed, that's what he
I'm
says.
filing a memo so that all the appeals can be connected.
No, I mean, I don't know about that because I am not a party.
Even before you made a statement, there is an order in your favor, that's what he's saying.
Yes, yes, that's
If that is so,
exactly.
then there is no requirement for any. State the operation and execution of the judgment.
This may be recorded.
Where is the order?
This order is not there.
We can,
It's uploaded on the internet.
we can draw it.
I had
on
filed
RFA
caveat so far as the defendants were concerned, since he was not a party.
But there's a
RFA number
statement that is made in the penultimate paragraph.
697 of 24.
The honorable court has stayed the operation and execution of the judgment and decree passed and so
RFA
and so
number
on 24.
897 of 2020.
RFA number 897
Order
of
dated
20.
24/2020.
Post along with.
Same OS.
Same OS, my lords.
Same OS.
May I request this, my lords? All the appeals may be connected and I may be permitted to file objections. It may be heard at once because this person was not a party. He has obtained a stay and he has confined
This
his.
will be connected. Same order.
Also, I may be permitted to file objections before.
That is your right. There's no question of permission, you can file objection.
Great.
Now, those two appeals that he is talking about, they have not yet been listed before the court. So I mean, I'm only saying the same order may be passed in this matter. Whatever order is passed in 897.
I may be at least permitted to file objections to this appeal if they are
If
not
such time,
connected.
No, there is already a stay.
There's a
Already
stay.
stayed.
No,
We'll
the-
only reiterate
No,
it.
but your lordship sees that is an appeal that is filed by a non-party. The person who has
We're
filed,
listing it together on the next date. Let
So-
all the appeals come
no,
together.
I'm just saying that
If
my-
there is an order, nothing happens in the meanwhile.
my only apprehension is this, my lord, that if something happens in that appeal over which I have no control,
Correct.
it should not affect my interest in this appeal. It's a statutory
Yes.
appeal, my lord. First appeal is a statutory right of appeal. Therefore, I'm saying same order may be passed in this matter is all.
At least I may be permitted to file objections.
In the meantime, till such time that he files objections and the matters are linked, my lord, let it.
I
be a stay.
undertake not to alienate or obviously I can't execute it.
So stayed for 12 weeks.
12 weeks, it'll expire on 17th of this month,
Monday.
17th of next month, I'm sorry.
Third, the learned senior counsel appearing for the appellant as well as the respondent. This appeal is against a decree for partition. Stop. A learned counsel appearing for the respondent would submit. There are 4 more appeals.
Yes, ma'am.
There are 4 more appeals arising from the same judgment and decree. It is also brought to the notice of this court that in terms of order dated 24/4/2024, the
24, he said 24.
operation of execution of the judgment and decree invoice number 6871 of 2007 is stayed for 12 weeks. Full stop. Pending consideration of the application seeking stay, the same stay order is granted till next date, staying the operation of the decree under appeal.
Obliged.
This matter along with. Your other respondents, you take notice? How many respondents?
Lots, I am appearing for the plaintiffs in the original
So in
suit.
this appeal,
In this appeal, they were defendants in the original suit.
6 respondents, he has already filed caveat or they are all the plaintiffs. The rest notice should
for
be out.
remaining respondents, there has to be
Notice has to be out.
issue notice to the remaining respondents. You appear for 1 to 6.
1 to 6.
Also appears for 1 to 6. Issue notice to remaining respondents. Great.
Preliminary hearing, Prakash Shetty, syllabus 31.
That's except for the petitioner, this is a covered matter and both are party in the earlier matter. Now you want to advance an argument, what was canoned before.
WB 16554 of 20.
Yes, that's
16823.
Yes.
Policy
Yes.
not challenged.
yes.
But yes, madam, that was some challenge.
What's the issue?
But the issue is, madam, study leave,
I understand.
grant of study. Madam, only, madam,
Yes.
the decision is rendered based on the provisions of section 17 of the Employee State Insurance Corporation Act. But kindly see, madam, it was extracted in the para 13 of that judgment, madam.
Regular pay scale estimate regular pay scale ಅವಾಗ 45 ಆ ಇವ್ರಿಗೆ ಯಾರಿಗೂ ಅಪಾಯಿಂಟ್ ಮಾಡಾಗ್ಲೇ 45,000 ಇದೆ. ಇವಾಗ ಎಷ್ಟಾಗಿದೆ ಅವ್ರು 45,000 4,575 ನೆಕ್ಸ್ಟ್ 4,570 2006ರಲ್ಲಿ 4,575 ಇಲ್ಲಿಗೆ ಟೋಟಲ್ ಪೇ ಸ್ಕೇಲ್ 33,000.
Madam, para 13, madam,
Of,
of the order, madam, passed in writ petition number 16554 of 22.
yes,
But they relied upon section 17, madam. For that, madam,
yes,
undisputed facts of the case are that the applicant is an employee of the ESI Corporation. Section 17(2) of the ESI Act reads as follows.
Hmm.
The method of recruitment, salary and allowances, discipline and other conditions of service of the members of the staff of the corporation shall be such as may be specified in the regulation. Kindly mark it, madam, specified in the regulation made by the corporation in accordance with the rules and orders applicable to the officers and employees of the central government, drawing corresponding scale of pay, provided that where the corporation is the opinion that it is necessary to make a departure from the said rules or orders in respect of any of the matters aforesaid, it shall be obtained prior approval of the central government. But kindly see, madam, the regulation exercising power under section 17, but I produced, madam, regulation in last occasion, madam, the regulations. But I will provide, madam, one more set, madam, along with the schedule, madam.
Para 14 regulation, they
Bande,
referred
bande.
by this honorable court.
But this is the stand, madam, they have never taken before the CAT. Now they are taking it, but kindly, but the Employee State Insurance Corporation Staff and Condition of Service Regulation 1959, madam. I have a copy, madam, for 2 sets.
copies are here.
But a schedule is not there, madam, along with the schedule, madam. Rule 7, Regulation 7, madam.
Regulations 15. Yes.
Madam, regulation 7.
Hmm.
Pay, leave, provident fund and age of retirement.
Hmm.
The scale of pay attached to the post under the corporation shall be as set out in the first schedule. But we are not concerned with that.
Hmm.
But leave. The regulation relating to the grant of leave, benefit of gratuity and provident fund to the employees and the age at which they shall retire shall be retired from service shall be set out in second schedule. But kindly take the second schedule. What do you think? Yeah.
Yes.
But a schedule.
Hmm.
Got it, madam? Schedule. I don't think, madam, it is there. Shall I pass on?
Only
Schedule
yes.
one
But
is
that
here.
is why, madam,
Yes, here, two is not.
I clubbed along with that, madam.
Hmm.
No sector. Madam. One more copy. One more copy. But the schedule two, madam.
Hmm.
Second schedule. The
Hmm.
condition of service employee in the matter of leave, gratuity, provident fund and the age of compulsory retirement shall be as specified against the relevant entry below.
Hmm.
Leave. The Central Civil Services Rules 1972 as may be applicable to the corresponding category of the central government servant from time to time.
Hmm.
But now CCS, CCA rules, that is leave rules, that is applicable, that is under the condition of service.
Hmm.
For Rule 50, it was extracted in the petition,
Hmm.
but Rule 50, condition of grant of study leave.
Hmm.
Subject to conditions specified in this chapter, study leave may be granted to a government servant with due regard to the exigencies of public service to enable him to undergo in or out of India a special course of study consisting of higher studies or specialized training in a professional or technical subject having a direct and close connection with the sphere of his duty.
Hmm.
Study leave may be also be granted for a course of training or study tour in which the government servant may not attend a regular academic or semi-academic course in the course of training or study tour is certified to be a definite advantage of government to the point of view of public interest and is related to sphere of duties of the government servant.
Hmm.
But sub rule 3 for the studies which may not be closely or directly connected with the work of a government servant, but which are capable of widening his mind in a manner likely to improve his abilities as a civil servant and to equip him better to collaborate with those employed in other branches of the public service. But this is provide for,
Who decides that?
that is the employer.
Employer.
Yes,
has to
madam,
decide.
exactly.
Employers decided that.
Yes,
it
madam,
is not.
that was not decided. But what they are saying is, madam, kindly see endorsement. which
Page
has been-
120, there is an order of. the
Allah, that is what,
division
your last kindly,
20 of the paper.
while granting a study leave, but this is the document which has under challenge before the tribunal.
Hmm.
But actually A7 is under challenge before the tribunal.
Hmm.
In application, your last kindly see the prayer which has been sought in the page 38, madam. And actually A3, which is under challenge before the tribunal. That is a condition imposed in the order is under challenge. And actually A3.
Can you, as a matter of fact, challenge it?
Please, madam.
Can you challenge it? What is annexure A7?
A3, madam, sorry, madam. And actually A3 is the condition they impose while granting a study leave, madam. That is page number 47 madam, of his writ petition.
Is pursuant to the policy.
Yes, exactly, madam.
Which is
Madam.
not under challenge. That is. a
Which was,
finding
yes,
in-
madam, which was challenged before the tribunal. No, which was challenged before this condition was policy was challenged before the tribunal.
Where is the challenge?
And actually A3, madam, page number,
Please show us what is the challenge?
but actually A3, page 47, madam. Permission to pursue higher studies, your lordship.
That is only the permission, the condition. of the
Permission has been granted with the following conditions.
Council, this very same issue was considered in the earlier writ
madam.
petition.
But
The earlier writ petition, the finding is that the challenge raised against such an order without challenging the policy is bad. in
policy,
law.
madam, your
And the policy cannot be challenged by you because it is a policy.
madam, policy, madam, while framing the policy, madam, approval of the central government is required under section 17(2).
You did not challenge the policy at all. Now, how is it open?
But
to
I
you to
was
say that-
challenged before the, madam, but your last in the Reshma Sudha case, madam, which was under challenge, that was challenged. In the earlier,
What
madam,
was
court
under
has
challenge?
said, that is, madam, of course, madam, I know that my constraint, madam, there is a, your last kindly see, the order passed by the tribunal, madam, your last kindly.
Please show us your challenge.
Madam, your lordship, kindly.
Challenge was against A3.
Madam, Madam, your lordship, in the original application, in the case of Reshma Sudha, this was challenged, Madam, your lordship, annexure A12, madam.
Council, we are considering your
Annexure
application.
A12, madam.
Come to
Page-
page 38. Come to
Yeah,
page 38.
88, madam.
Your application. you
Your,
are
my,
asserting
in
now-
my application, that was the condition only I challenged. But in earlier, it was already set aside by. Tribunal has said it is illegal, arbitrary. That is was the finding of the tribunal. madam. In the Reshma Sudha case, madam, your lordship, kindly see in the writ petition, madam, your lordship, it is there in the order itself. madam.
Yes,
To quash the study leave dated 13/11/2 passed by the second respondent, dated 31/10/2018 passed by the second respondent, actually 15. That was challenged before the tribunal.
yes, here also.
Well, that has been dealt at para 16 and division bench. It was not set
Just a
aside.
minute, just a moment.
My lord, in the division bench had dealt aspect at the para 18. That was
Yes.
challenged, that was not been struck down by the division bench of the Honorable High Court.
Yes,
In view of the subtle position of this court, that they have para 16, they said. The
yes.
division bench further held that there was no challenge to the policy. As rightly by the Radhanet advocate for the applicant had challenged the policy annexure A, the 15.
Hmm.
The CAT. However, without examining the virus of the policy, CAT directed ESE to review the policy guidelines to the nursing category employed to pursue the higher studies by keeping the Indian Nursing Council continuing the nursing education regulation 2019 in mind, that the CAT has not quashed annexure A15. So long as annexure A15 was in force, ESI will be guided by the policy.
There was a namesake challenge at least.
Yes, madam.
Even then, this court held that it cannot be.
Hmm.
Because the CAT had not
Madam.
said.
Madam, may I make only one submission?
Your
I agree,
case,
madam.
you don't challenge.
Madam, madam,
Yes.
only one, madam. That was challenged. Now anyway, that is matter before the Supreme Court. Madam, what, madam, tribunal has said, madam, what I say, madam, para 18 on the page number 158 for a moment, madam. That
Yes.
was, there should not be any mistake, madam.
Yes,
Para 18, madam, in that case.
yes,
Keeping the above points in view, the act of the respondent to deny the study leave to the applicant relying on their policy 2018 can be considered as being arbitrary and not justified in the line of requirement as framed under the Indian Nursing Council Act.
yes.
But actually it was, they said, madam, indirectly they said, instead of cautioning the madam, indirectly they said
But
that it is an arbitrary and illegal.
Indian Nursing Council Higher Studies Education will not applicable for the employment. But that is how the tribunal misconstrued it. But with great respect, tribunal has not understood what is the law governing on the field.
Therefore, this order is a per incurium, what I am saying is, madam, the earlier judgment is per incurium, because this point was not 17.2, madam, what?
Point is per incurium.
Madam, 17.2 regulation, madam, that is why, madam, 17 I framed under the regulation. But this point has been covered under the regulation. If they deviate, then the approval of the central government is required to be obtained. That was not obtained.
But
Yes.
study leaves has been decided by the Supreme Court and division bench also. That is, I have got it. Then we have produced in a reply statement, the division bench of the Delhi High Court. They said that the regulation will prevail and they have no right. That is page 122, your lordship will get the order of in the paper book. The detailed order of
22.
page, it starts from when your lordship, page 120, the order of the Delhi High Court, division bench, the
Yes.
same regulation.
Yes,
The Asha Rani versus Union of India. Then, my lord, division bench, your lordship will get it at para 4. The study leave has been dealt at para 4.
yes,
Then, my lord, the regulation also they have dealt it. Your lordship will get it at page 123 at para 5.
yes.
Division bench.
That are all
Same
considered,
question has been.
that were all considered by the
That
tribunal.
means
Yes. Petition is filed, seeking the following reliefs. Heard the learned counsel appearing for the petition as well as the learned counsel for the respondent. Second respondent is the government. Second respondent is the government.
The second respondent is,
Government College of Nursing.
no, the,
That is the where madam, I took admission, madam. That is the college.
Yes, as well as learned
Private college.
government advocate appearing for the former respondent. Former second respondent. It is submitted by the learned counsel appearing for the petitioner that the first respondent had been appointed as a nurse in the fourth petitioner institution in 2013. She had the qualification of BSc in nursing. It stated that the second petitioner ESI had taken a policy decision that the nurses in the corporation would not be entitled to study leave for higher education. It is further contended that post-graduation in nursing is not a prescribed qualification for nurses in the fourth petitioner institution. It is submitted that the request made for study leave by the first respondent was rejected by the fourth respondent. Annexure A3 is the order.
not the,
Yes,
the
madam,
order of the
before the
tribunal,
tribunal.
yes, your lordship. said,
Conditional.
The
Uh,
page 140,
was granted
148.
to the first respondent. Don't say it was rejected. The application made for study leave by the first respondent was granted with the conditions as specified in A3. It was specified in annexure A3 that the study leave would be granted only as personal leave, HPL, or extraordinary leave. And that would not affect the normal duties and exigencies of service. The first respondent approached the tribunal challenging the conditions as provided in annexure 3. The petitioners had entered appearance and filed objections stating that grant of study leave is a matter of policy and that a policy decision had been taken by the corporation not to grant study leave for acquiring the qualification of MSc in nursing, since MSc in nursing is
But
not
I have policy
a
decision, page
requisite
128, I have produced it. Page 128, the policy decision I have placed it
The
before.
policy decision was also placed on record. The tribunal, however, relying on the earlier orders passed by it, including in OA number 258 of 2022, proceeded to allow the OA and direct the review of the policy as well as the grant of study leave to the applicant without insisting on the conditions as provided in annexure A3, relying on rules 50 and 51 of the CCS leave rules 1972. Full stop. The learned counsel for the petitioner submits that the order of the tribunal in OA 258 had been subjected to challenge before this court in writ petition number 16554 of 2022, and a judgment had been rendered on 16th August 2023. Setting aside the said order on the ground that policy decisions of the corporation were not subject to challenge at the instance of individual employees. The writ petition was therefore allowed. Orders passed in the OA by the CAT were set aside, and the original application stood dismissed. Full stop. The learned counsel appearing for the, it is therefore contended that the ratio of the judgment is applicable to the instant case as well, where the applicant has not even challenged the policy decision of the corporation. The learned counsel appearing for the first respondent would contend that the Employees State Insurance Corporation Staff and Conditions of Service Regulations 1959 provides that pay, leave, provident fund, and age of retirement of employees would be as set out in the second schedule appended to the regulation. It is submitted that the second schedule to the regulation, provided that the Central Civil Services Leave Rules 1972 as applicable to corresponding category of central government servants from time to time would be applicable to employees of the corporation as well. It is therefore contended leave rules. It is therefore contended that the provisions of Rule 53 of the leave rules would be applicable in the instant case as well. However, Rule 53 provides for conditions under which study leave shall be granted, or rather provides the conditions where study leave shall not be granted unless those conditions are met. The rule specifically says that study leave shall not be granted unless it is certified by the authority competent to grant leave that the proposed course of study or training shall be of definite advantage from the point of view of public interest. In the instant case, the ESIC, which is the employer, has taken a policy decision that study leave shall not be granted to pursue higher studies, that is MSc or BSc in nursing, since there is no functional requirement for a degree of MSc in nursing in the ESIC, and that therefore the course cannot be said to meet the precondition as per Rule 53 of the 3CS leave rules. This policy decision of the ESIC was not under challenge before the Central Administrative Tribunal in the instant case, full stop. In the above view of the matter, we are unable to accept the contention raised by the learned counsel appearing for the first respondent that the judgment of this court in WPC 16554 of 2022 is per incuriam, or that it was misconceived in any manner. We are of the opinion that the matter raised in this writ petition is squarely covered by the judgment in WPC 16554 of 2022. This writ petition therefore is liable to be allowed. The writ petition shall stand allowed. The order of the CAT dated so-and-so in OA so-and-so is set aside. The original application shall stand dismissed.
One submission. SLP has been filed.
Yes, it is submitted that an SLP has been filed against the judgment. Yes. Per incuriam only we are answering.
32, Nagaraj ji.
The
Reduction of
applicant's
pension.
petition. No. Yes.
Person for
yes,
5 years.
Yes. Lord,
It is upheld by the,
yes, Lord, the allegation, Lord, that on 3rd September 2010, a complaint was registered by one wife of one Ramachandra. On the allegation that, Lord, on 28/8/2010, some 8 persons went for hunting for a wild boar. Lord, while they were hunting.
you've seen the allegations.
Yes, Lord, that in that way, Lord, the offense, Lord, under the Atrocities Act will not attract. Because they have no knowledge that the deceased who died belongs to scheduled caste. Therefore, Lord, rightly he has deleted those offences. That is the allegation.
302 was there.
But 302 also not attract, because he has not seen the person at all. A person was hiding in bush. Lord,
What was the allegation against you? What was the charge?
Lord, I
against you?
deleted, Lord, the offense under section 302 and offences attracting, Lord, under the Scheduled Caste and Scheduled Atrocities Act. Because 9 persons who shot, Lord, at the bush were not knowing that a human being was there. Lord, on the face of, and the session judge, Lord, acquitted them. Lord, ultimately charge sheet was filed. Kindly, Lord. The charge sheet was filed, kindly page 144. The charge sheet was filed for 304A, not even 302. I was not knowing some human being was there. The accused persons were not knowing that human being was there. Therefore, Lord, because he's a deputy superintendent of police, Lord, a experienced person, Lord, he has gone through the entire records. Lord, rightly, Lord, he deleted section 302 and the offences under section Atrocities Act. Because they have.
Faced a full inquiry?
Yes, Lord.
What was the finding in the inquiry?
Finding, Lord, that inquiry report was not produced before the tribunal, Lord. It has been called out, Lord. Finding, Lord, I had the
Please show us the charge memo.
Charge memo, kindly. Page number 82, Lord.
Page number?
82. 82. Page number 82, Lord, dated 2014. After 4 years, Lord, they initiated after my retirement. He retired in the year 2013. After 1.5 years thereafter, he retired. He charge memo was filed.
Neglected his duties.
Kindly see, Lord.
Dereliction of duty is the finding.
One of charges 2.1, page 83. You did not take suggestion of legal experts. Lord, he is the investigating officer. Lord, he is his satisfaction that certain offences are not attracted. And Lord, I have brought the notice of the higher superintendent of police. Lord, superintendent of police was also examined before the inquiry officer, who says, Lord, I have done all the investigation legally and as per law. I have produced the statement of the superintendent of police, who was then my superior. I have brought to his notice that, Lord, whatever I have done, I have informed him, and he has permitted to go ahead.
What were the findings in the inquiry? You have not produced the inquiry.
Inquiry officer not produced with trial court, tribunal, Lord. Lord, I just called out, Lord, in the order of punishment, Lord, it has been called out. Page number 195, Lord. The inquiry, the punishment order starts at, Lord, 188. Lord, page 195, Lord, para-wise, Lord, they have answered. Kindly see. Articles of charges, inquiry report. Page 185.
195 page. Other 85
Some incomplete papers for furnished. Not the allegation that
Just
I have.
written a letter to the so-and-so.
Not have dropped not 2 offences.
Letter in so-and-so.
Now they have been acquitted, Lord. Now they have acquitted. I have produced judgment of Sessions Court also.
That's quite another matter.
Let them to furnish proper copies.
I'll furnish.
Copies are,
Not, I have furnished, but not properly. I'm sorry.
please furnish proper copies. When?
Tomorrow I'll furnish.
Next week. Next week.
Next week.
Please.
The petitioner shall furnish proper copies to the learned council, learned government advocate appearing for the response.
Next week.
33, Vijay Kumar.
Transfer,
Relates to
Competent.
transfer, my lord.
competence of the.
PDO.
Everything is, my lord, served on my learned friend and the PDOs. my
Hear it
lord.
today,
Please,
you're ready?
because. my lord,
2:30, I may have some, can I have a parted banter in court online, continuation matter. That's my only difficulty. I think, my lord, your lordships have disposed of the other day also pertaining to the very same transfer, my lord. Because it's just a district-wise cadre, then it became a state-wise cadre subsequently.
Yes, my lord.
That
There is
But we
already an
discussed-
amendment to.
that
P&R,
your
my
lordships
lord,
have
that has-
disposed of. Now, my lord, the only thing is, if there is any observation that would affect this, amendment is in March 23, 24. So can an
Subsequently, they
order
have-
of October 23 be,
Have you
Executed
seen
on
the-
the basis
no,
of-
my lord, we have not seen, that's why I'm,
Please, look it up. If
yes,
you're
exactly what.
not aggrieved, we can dispose it of.
All
on
right,
the
if
very same
it
line.
can be disposed of on
Can be
those
disposed of, but my lord requires some consideration because the petitioner, my lord,
Please see the judgment.
please, my lord, I'll see the judge.
Please,
May I
Very
request
well.
to have this matter on Tuesday, my lord?
judgment, please, if it's not, please upload it so that if
Very well.
they can see it and.
In terms of that, if it can be disposed
If
of.
it can. be
I'll go
disposed of,
through the
it's-
judgment.
If both of you are
Very
agreed,
well.
it can.
May I request this matter to be taken up on Tuesday,
Wednesday,
Tuesday, Wednesday, please?
Wednesday.
Very well,
Very well,
great.
great.
34,
Inquiry.
Inquiry.
Has the inquiry started? This for your instructions that we had posted.
No, the inquiry has started. He has challenged the notice issued. My lord, in fact, this writ petition does not deserve any consideration
It's
because
not the issue. He says that the inquiry was initiated. Several times it was posted for all the inquiring officers are
no,
accusing.
that was previously, my lord.
Hmm.
In fact, when that was
Thereafter, inquiry
happening,
has started.
criminal proceedings were parallelly going on. That came to a conclusion with the conviction of the petitioner.
Hmm.
Therefore, dispensing with the disciplinary proceedings, penalty was imposed.
Hmm.
Thereafter, he was in appeal
That was
through a
set aside.
compromise.
Hmm.
He was acquitted in appeal.
Therefore, it had to. go
Having
back.
regard to that, KAT,
Now, after that, has the inquiry started?
after that inquiry notice has been issued, that has been challenged in this writ petition. However, the order where the honorable tribunal in the earlier round of litigation gave liberty to the disciplinary authority to initiate the inquiry, that has not at all been challenged. What he has challenged is the subsequent order of the notice issued to him to appear before the inquiry. He has not at all challenged the order of the tribunal.
We only wanted to know what happened thereafter. Is the inquiry proceeding?
Notice has been issued. He has challenged it before the tribunal.
There is nothing, no interdiction against you. So have you proceeded?
He has not appeared before the inquiry.
We have appeared. We have appeared.
It was a contention last time.
But-
He said he's appeared, but then nothing is happening. It's remaining in a limbo. We'd asked you to get instructions whether the inquiry is proceeding, what time you require to complete it.
The time, yes, ma'am, the time frame required, my lord, but however, since he has not challenged the KAT order,
Suppose we dismiss this and you keep it pending and do nothing about it. How is that fair?
within a time, the court,
This is all we
honorable
asked you to get instructions.
court may fix a time frame and dispose of the writ petition, my lord. Because he has not challenged the,
Again, an inquiry officer has now to be appointed.
he has been, and he has issued the, in fact, he has
Yes.
been made a respondent, my lord. The inquiry officer himself has been made a respondent.
After the tribunal's order, an inquiry officer has been appointed.
Yes, ma'am.
And
My lord, may-
thereafter, when was notice issued?
May I bring to the notice of this honorable court, the conviction matter is not at all the not at all the matter in the disciplinary.
Whatever that be. Now the disciplinary proceedings have started afresh as directed by the tribunal in the earlier round,
My lord,
not under challenge.
no, ma'am.
Therefore, that proceedings have to go on.
Certainly,
Or
my-
that the
certainly, my lord, the honorable Supreme Court says in several judgments, delay in conducting the proceedings is nothing but mental agony to the departmental inquiry proceedings.
Just to demonstrate where is
Respect
the
to
delay.
applicant.
There was no delay at all. Criminal proceedings.
Several
reporting-
decisions.
Counsel, the order, there was a conviction.
Yes,
On the basis of a conviction, a dismissal order was
that matter is
rendered.
not within the departmental
Is-
inquiry, my lord.
There was a conviction.
Yes, my lord.
You could have been dismissed on the basis of the conviction.
Yes, my lord.
You were dismissed on the basis of the conviction. The conviction came to be set aside on whatever grounds.
Yes,
Therefore, that order of dismissal goes.
yes, madam.
You have to face the inquiry because there was already a charge against you.
Yes, madam. Yes,
Therefore,
madam.
that procedure started again. You had not challenged the order of the tribunal saying that the inquiry can go on. Is that right? Liberty was given to the respondent authority to conduct regular inquiry against the applicant so far as the charge against him are concerned and to proceed in accordance with law. When such liberty is given to the respondent authority to conduct inquiry proceedings, duty of the applicant is to
Yes,
appear
ma'am.
before
That
the.
Even, even
order
after
can be
that
noticed.
order, after that order, 2 years, they have not conducted any inquiry.
This order is dated 9th November 2021. Notice is issued on 10th February,
Yes, my lord.
within 4 months.
There was no any stay order stay regarding inquiry of proceedings. Even in spite of that, they have not conducted any inquiry during that period.
No, 4 months.
Only after order passed by the tribunal in
Lord, I'm told that there was a stay order by the KAT.
That is what we are
A
asking.
lot of things are not being,
This is what we are asking. Is
my lord,
there a
in
stay
fact,
order?
that is
In
after
fact-
2022,
My
my
lord.
lord. Prior to that, there was no stay order.
my lord, may I just pass on? There was a writ petition filed against the, my lord, your lordships may kindly peruse the order at page 85.
Hmm.
This was in the earlier round of litigation at Annexure K, my lord.
Hmm.
This order has become final insofar as the petitioner is concerned. This was the order passed by the tribunal.
Page number?
Page number 83, it starts at 85, my lord, Annexure K. And the relevant portion is at page 95.
Page number is not correct, but Anisha K, yes.
However, with liberty to the respondent authorities to conduct regular inquiry against the applicant so far as the charges against him are concerned and to proceed in accordance with law.
That was on 9/11/21.
21. This has not been challenged. In fact,
We
the
understand.
state has challenged this, my lord.
Oh, state.
There
has
is a
done.
notice has been issued already, and in that an interim order has been passed. Where he accepts that inquiry may go on and my salary may be paid. This is the order passed. And
My lord,
it is stated that permitted.
this particular matter is regarding only dismissal, my lord.
It has been
Still-
recorded that the government may be permitted to go ahead with the inquiry,
After it is
and it is
recorded by
stated
this
that
court.
permitted.
In previous proceedings also, the same thing was recorded, my lord. Even in spite of that order, they have not conducted inquiry.
When did you appear before the inquiry officer?
My lord.
When did you appear?
I have appeared previous, much prior to the notice issued under annexure L, my lord.
When?
When that I have to check.
Not the earlier inquiry officer.
Yes,
The inquiry officer
previous,
now
present,
appointed.
we have not appeared before the present inquiry. Earlier, before inquiry, before,
How can you find fault with them for not conducting the inquiry when you don't?
my lord,
appear?
there was a time fixed by the government to conduct an inquiry. Within that time, they have not conducted any inquiry. Even in spite of my presence before the inquiry officer, they have not,
When did you
even
appear before the
they
inquiry?
themselves admitted in their objection, my lord.
That was the earlier inquiries we are
Yes,
talking
madam.
about. When did you appear before this inquiry officer?
No,
You appointed?
before this
can
inquiry
you find
officer, we
fault
have
with
not
them?
appeared because we have filed a
How can you find
application
fault
before
Earlier, he
KAT.
mentioned that he has appeared.
completing it in time? Not in your mouth to say that, counsel. When you do not cooperate with an inquiry, you cannot be heard to contend that they are
Yes, my lord.
delaying.
We
the
have
inquiry.
filed an application before the
Absolutely
KAT. KAT has granted a stay order. That's why we have not appeared before the
No, you said,
officer.
you said even without any orders, you're making
Lord,
submissions
Earlier,
which are.
earlier to present presiding officer, before earlier officer, we have appeared.
We've heard the learned counsel appearing for the writ petition. The writ petition is filed challenging the order of the KSAT
May I make a submission,
Application
madam?
number 727 of 2022.
There is
Dated
this-
24/6/2023.
Honorable Supreme Court citation is there, madam. There is a delay. When there is a delay in
Consider.
conducting,
We'll consider that, Council. We are aware of the citations. The tribunal had considered, the challenge was against a notice dated 10/2/2022, issued by the second respondent as annexure 810, which required the presence of the petitioner in an inquiry to be conducted into the charges framed as against him. The learned counsel for the petitioner contends that the charges were framed, the charge memo was
2-3. My lord,
was
7.
issued as
2/3,
early as
2018.
2018, madam.
2
2-3-2018, wide annexure C, my lord.
2018. And that the delay in conducting the inquiry therefore vitiates the later proceedings, including annexure 810. The learned counsel would seek to place reliance on the judgments of the apex court with regard to the delayed conduct of inquiry. Get the judgments that is relying. It is contended that since the inquiry proceedings have been dragged on for several years, it would not be proper at this juncture to continue the inquiry as against the petition. Full stop. We've heard the learned government advocate also. It is contended that the facts of the matter are clear from the order of the tribunal itself. It is submitted that earlier inquiry proceedings were initiated against the petitioner, and the inquiry officers had recused from the inquiry, and the matter was being delayed on one account or another. It is submitted that the inquiry could not take place on account of the fact that the inquiry officers appointed did not conduct the inquiry. Full stop. It is submitted that in the meanwhile, a criminal case had been registered against the petitioner, which ended in his conviction. Full stop. It is submitted that the petitioner had been dismissed from service by had been dismissed from service
3/7/2021, madam.
on 3/7/2021
Yes.
on the basis of the conviction in the criminal case. However, later, the conviction in the criminal case came to be set aside, and the petitioner had challenged the order of dismissal before the tribunal. The tribunal considered the matter and held that the dismissal would not survive since the conviction has been set at naught. Full stop. The application number 3153 of 2021 was therefore allowed on 9/11/2021, directing the reinstatement of the petitioner. However, it was specifically directed by the tribunal that since the charge memo had already been issued against the petitioner, the inquiry proceedings could go on. Full stop. This order of the tribunal was not challenged by the petitioner. It is thereafter that annexure 10 notice has been issued to the petitioner to attend the inquiry. Full stop. The tribunal, after considering the
It's annexure
contentions,
E in the writ annexure C in the writ petition.
the tribunal, after considering the contentions advanced, found that the inquiry notice dated 10/2/2022, which is under challenge, has been issued to the petitioner in the light of the earlier directions of the tribunal in application number 3153 of 2021, which was on record as Annexure C before the tribunal. It was specifically found that the tribunal had set aside the impugned order of dismissal dated 3/7/2021, but had given liberty to the respondent authority to conduct regular inquiry against the applicant, so far as the charge against him are concerned, and to proceed in accordance with it. It is submitted that the state had filed a
writ petition.
as against the said order of the tribunal, in which
I passed on
Double
two
five,
copies.
6 of 2000.
Double five, 5566 of 2022.
566. Yes, sorry. Which was considered by this court on 25/7/2023. There was an interim order staying the impugned order dated 26. It was held that the interim order staying the impugned order dated 26/2022 is unnecessary, and the same was vacated. It was
Last part.
it was, the government was directed to go ahead with the inquiry. This order was minuted as early as on 25/7/2023. However, it is submitted that even thereafter, the petitioner had not appeared for the, appeared before the inquiry officer. It is further stated that there was a interim order of stay of further proceedings in the inquiry before the tribunal when the application was pending before it, full stop. Having considered the contentions advanced, we are of the opinion that since Annexure C order of the tribunal dated 9/11/2021 has not been challenged.
Annexure
by
K,
the-
K, my lord.
K, not
K.
C.
C is the order challenged
No, Annexure K.
in this
order of
writ
the tribunal,
petition.
Dated 9/11/2021 was not challenged by the writ petitioner. He cannot contend that the present inquiry held against him was illegal or delayed. Full stop. It is also now admitted that there was an interim stay pending this, pending the current application, that is application number 727 of 2022 before the tribunal. Full stop. In the above view of the matter, the petitioner who has refused to appear before the inquiry officer cannot be heard to contend that the inquiry is delayed and that the inquiry cannot be proceeded against at this stage. We are of the opinion that that in the facts and circumstances of the instant case, the order of the tribunal was perfectly justified. We find no merit in the challenge raised by the writ petitioner. The writ petition fails, same is accordingly dismissed.
Time may be fixed for concluding the.
We're
department.
not inclined, comes, not at your instance. Yes. Who appears against you? 39? Only the state. Yes.
Serial number 12, my lord. I have some parted matter in the afternoon, my lord.
19th, I'm sorry, 19th may not be. Yes, is.
Serial number 12, my lord. I have some parted matter, my lord. No, I was ready in the morning, my lord. I was waiting, my lord.
Where not.
Lord,
Yes. Yes, we'll consider.